From content
My lord,
application.
may I mention my item number 341.
Upgradation.
No, in the
Upgradation
monthly
not
list,
possible.
in the monthly list, there is some urgency, my lord. But
Everybody has
I-
urgency.
I-
Motion matters, just hand over the
Yeah,
motion.
motion for inclusion upon
Done for-
content
Taken
application. Content application for violation of the order.
Upon notice, my lord.
Just motion matters, just only motion matters, hand over the.
My lord, may I be allowed?
Wait, sir. Mr. Saha.
Number 98, the monthly list.
Upgradation.
Upgradation. This is very urgent, my lord. Otherwise,
No, sir, sir.
otherwise matter would be.
I cannot deprive anybody. I cannot deprive anybody. Sir, don't embarrass this court, sir. Sorry. Yes, sir.
My lord, may I, my lord, most probably on Thursday, my lord, Mr. Supratim Dhar and Shopan Banerjee, with the help of Mr. Shopan Banerjee, mentioned before your lordship two matters. My lord, similar matter, my lord, if your lordship kindly fix it on tomorrow, my lord, it will not take more than 5.
Upgradation.
No, my lord, it's not there in the list. My lord, it's a new motion, urgent basis, your lordship.
No, sir. I cannot.
Lord, may I mention for inclusion of our content application for violation of the order passed by your lord.
Yes.
If item number 297 of your lordship's monthly list, my lord, and the urgency is that, my lord, this is
Upgradation.
the upgradation I'm
No,
saying.
sir.
the
I'm
urgency
not
is that, my
entertaining.
lord,
I'm not entertaining.
Your lord,
Don't embarrass.
mentioning for enlistment.
Mentioning for
Enlistment, sir.
which heading?
So restoration of
Give.
like, any time if your lordship allows.
Mentioned 3 contempt matters. Your lordship had mentioned earlier, and your lordship was pleased to allow, but only 2 had come up out of the 5 matters.
কি ব্যাপার no. Yes.
Upon your lordship permission, I am mentioning my matter for release, your lordship. Matter has been wrongly listed.
Very good. To be mentioned tomorrow.
My lord, it won't.
No, sir. I'll not.
Well,
Don't
any time
embarrass.
if your lordship directs
Sir,
me,
no,
I can
sir, no,
come
sir.
back, my lord. The urgency is that,
I
my lord,
cannot deprive anybody.
Well,
Everybody is waiting
well, only respect to
for
urgency.
upgradation on account. If I allow the
I bow
upgradation,
down,
I
my
have to
lord. Your
deprive.
lordship list is very well exhausted.
Sir,
Well, only
court
one.
hour
prayer,
is
my lord.
limited.
Well, only prayer.
Court hour is limited, sir.
Well, if your
No,
lordship
no,
directs me, I can come back.
I said consider in the month of July. Not now.
Restriction
All
taken
the
by the authority, my lord, notice has been issued against me, my lord.
Well, let them remove, sir. No issue.
For the petition, আমরা first time appearing. My lord, the order dated 19th August.
It's my order or it has been assigned to
My lord's order. Order starts at page 17.
17.
17, my lord. Operating portion is my lord, page 29, my lord.
29. Give me a second, sir. আপনি না paragraph, sir?
The second line from top, the respondent number 2 is hereby directed to disburse the admissible amount of subsidy in favor of the petitioner.
I'm sorry.
Page 29, my lord. Page 29.
Paragraph 27. Respondent specific respondent number 2 authorities hereby directed to disburse the admissible amount of subsidy in favor of the debt prisoner towards state capital investment. Oh, I see. It has not been complied with.
Not, my lord. The communication is, my lord, page 31.
Very good.
My lord, thereafter, my lord, notice has been issued, my lord, for non-compliance. Notice as my page 34 is the my lord, notice.
আসুন on perusal of the Next.
For the fiction. Let's have the copy of the content.
এই এফিডেভিট সার্ভিসটা দেখুন। Service has been effected, Mr. Mukherjee.
My lord, by hand service.
The affidavit of service as filed today on behalf of the next.
Lord, I beg to appear on behalf of the alleged contemner. Page 20, internally page 7, paragraph 21 of the impugned order are the directions passed by your lordship.
Give me a second, sir.
Paragraph 21, my lord.
DI of school. There are two, you are appearing on both the
Both are district inspector of schools, my lord. I appear for both of them.
Where is my order?
My lord,
Mr. Mukherjee, where is my order?
Yes, my lord. Order, my lord, page 59.
Where is the operating part?
My lord.
paragraph 20 of that, my lord.
20.
20.
Since in the minute it's a transfer
Page
from
65.
respondent Hogli Chinsura and distance में Bhadavan are directed to take a stage for fix higher scale of payment. Yes,
Essentially, my lord, two directions from your lordship, my lord, fixing the higher pay scale from the date of appointment, which the district inspector of school has already done. May I place the report before your lordship, my lord? So now, on fixation for
Only for my lord, paper dealings, my lord. I have not received any.
Look, that the my lord, college has to, school now, my lord, has to, my lord, forward the documents regarding his.
give me a second.
I'm sorry, my lord. Second page, my lord, will kindly come to. Lordship will find.
In compliance of the order date such and such, the DI of school, Purva Bardhaman being respondent, they already it should be granted higher scale of pay in favor of the petitioner from his date of appointment, that is wide office memo number such and such date 17/6/2025.
Mal.
Copy enclosed.
Mal. Next page is the copy, my lord.
In compliance of such and such, with effect from he is also requested to pay to being the understanding is hereby sanctioning the postgraduate scale of pay with effect. He is requested to submit the area due bill without any interest in favor of the petitioner to the office of the undersigned.
My lord, two parts of the order, my lord. One says, my lord, fix the higher pay scale.
Yes.
That has been done. Second part, your lordship has also directed, my lord, payment of the areas amount. My lord, will find the next page, my lord, of my report. My lord, I have addressed this letter to the head of the institution of the particular school, my lord. My lord, requesting him to pay, my lord, place the area bills.
He is also requested to submit the area pay due bill.
He has to do that, my lord. He is not a party to this contempt proceedings, but I believe, my lord, if he has added as a party to this contempt petition, my lord, that will expedite things. Now, my lord, the ball is lying on his court, my lord. He is to, my lord, send this area bills and we have to, my lord, take
Yes, sir.
care of that.
Direction was given to the, my lord, the DI of, DI.
I understand that, but DI has,
District Inspector.
the DI cannot, my lord, on his
No,
own
so far as
calculate.
the fixation of higher scale of pay, that has been done.
Done.
Done,
That has been done. And the same has been communicated to the head of the institution.
My lord.
my lord.
And so far the issuance of payslip is concerned, issuance of payslip,
My lord, the area payments, area, my lord, dues.
no,
Are-
no, sir, kindly come to page number 66.
First of all, my
You have granted sanctioning, you granted you have granted sanction for postgraduate scale of pay.
My lord.
Then what about the issuance of revised payslip?
Lord, my report, my lord, doesn't reflect that, but certainly if not, we'll immediately do that. Perhaps that is done. What has fallen from the court, my lord, perhaps that is done.
My lord,
Because
can you
if
fix
the,
the date, my lord?
if the area pays are fixed, my lord, if the
Kindly fix the date. We should,
higher pay scale has been given, that will, my lord, automatically fix the pay scale.
No, where is that document? High scale, it must be attached.
The
Is the
moment,
enclosure,
my lord, the higher pay
complies
scale.
are undersigned being is hereby sanctioning in favor of the ATU with effect from the date of his appointment. He is requested to say area payable without interest to the office of the ATU within stipulated means also.
first of all, my lord, scale was fixation. Thereafter, my lord, area.
No, first is fixation of scale of pay.
Yes,
Higher
Second
pay scale
is-
given, that means
Second is issuance of revised pay slip.
yes,
Third is
area.
calculation, area pay of history, calculation of the area pay and disbursement of the area pay. These are 4 components. I find that only one component has been complied with.
possibly, my lord, subject to correction, 2 and 3 are consequential. My lord, we'll ensure that. If not already done, we'll ensure that.
Well,
My lord, may we get some observation?
kindly fix the date.
Ashun. headmaster as a party?
No, my lord.
No. Very good.
He will do, he will do.
Absolutely, absolutely, absolutely.
Item 4, my lord, I appear on behalf of the petitioner, my lord. Lord, the facts before your lordship is
Give me a second, sir.
very well.
Is there any private respondent?
I have served everybody, my lord. The basically
Look,
the
sir, there is no
contesting
private
respondent,
respondent, state, and I'm for
contesting
respondent.
respondent is the state, my lord.
Mr. Banerjee is appearing for the state.
For the state.
You are
I'm
for?
for respondent number 8, West Bengal Mineral Development.
Already matter has been heard. Interim order was extended from time to time. Lastly, is toward extended by your lordship, and that is till 30th.
Respondent number 8 এই মামলাটা ঠিক দিয়েছো তো? What is the name of your client? Utpolendu Bokshi?
Yes, yes,
Yes,
Utpal and the books.
Respondent number 7 is there.
Yes, yes, 7.
No, no, respondent number 7 is a BLRO. Who is your client, sir? Mr. Saha,
পরবর্তীকালে অ্যাড করা হয়েছে।
you are appearing for?
My lord, I'm
Please,
late by.
please,
Oh,
please.
Mr. Saha is appearing?
তো আগের দিন ওইখানে ছিল বলে
হ্যাঁ, আমাকে কি পরবর্তীকালে অ্যাড করা হয়েছিল
না।
as respondent number 8.
Mr. Sanjoy
But
Saha,
notice has been served upon.
No, no,
Mr. Raju Kundal. for the-
Director of Mines and Minerals. Are you appearing for?
No, no.
You appearing for whom?
But the copy of the writ application has been served.
Then that would be there in the order, my lord.
Respondent number 6. I don't know who is appearing.
Since my client is not a party, so I will not appear in this matter.
Well,
May I, my lord, tell your lordship, my lord, the fact,
Give me a second, sir.
lordship.
No. Mr. Saha, you are a party. You have been added as a respondent number 8.
Yes,
West Bengal Mineral Development and
I
Trading
believe on the first day when the matter was moved, I was added as a party and copy has been served.
Yes. It is there. I missed that page.
পরে add করেছি, add করে copy served.
Yes.
My lord, I tell your lordship, my lord, the facts. My lord,
T-level
first
order.
went to an auction, my lord, the petitioner participated, my lord. And petitioner was given 5 years lease
Level
agreement for
development.
extraction of sand. Now, during the interregnum,
Trading Corporation Limited.
an allegation was made against the petitioner, and petitioner, without going into that controversy, accepted and paid
What
penalty.
type of allegation?
Allegation is, my lord,
You have exceeded your area.
exceeded my area and probably extracted more than what I was supposed to do. Now, my lord, be that as it may, my lord, I paid the penalty. I also paid the entire royalty fee, 4 lakhs. Suspension continued.
Suspension continued.
Now, finally, my lord, they revoked the suspension on 19th of May. Thereafter, I continued. Now, my lord, today,
19th May of
2023.
2023.
Suspended on, dates are important, on 7th March
March
2022, first time.
Suspension issued on
On 7th March 2022, page 25 of the rate petition.
7th March 2022.
22.
Page number?
Page, my lord, 25.
Yes.
Now, my lord, I paid the penalty on 20th October 2022. That is at page 29, admitted position.
Page number 29 is the
Payment of penalty, including the royalty. I paid total 4 lakhs. Additional payments have also been made.
penalty plus royalty. Yes.
29 would reflect that I would paid the penalty.
Yes.
Now, my lord, the fact that the suspension was revoked, that would be evident from an order of the court, which is at page 39, passed on a prior writ petition. That is at page 39, and therefrom it would appear that the authority that has revoked the suspension on 29th of May. My prayer before your lordship today in this writ petition,
Revocation of suspension.
withdrawn on 29th of May.
29th of May of which year?
2023.
Yes, then
Now, my lord, my prayer before your lordship is, since, my lord, I have paid the penalty, everything, my lord, for that period after payment of penalty, when they delayed the entire procedure, I should be given a 7 months extension. That's my only contention.
How can it be? It is because of your own fault you have.
Absolutely.
Then
My lord,
you have accepted that.
I have accepted that.
Huh?
I have accepted that. Now, my lord, the day I paid the penalty, suspension should have been withdrawn on that day itself. They could not have delayed it. I have made representations. I have written letters.
No,
I accept that. Supposing, my lord, a penalty.
When penalty was paid?
Correct, my lord. Penalty was paid, my lord, on 10th of October 2022. They couldn't have withheld it again.
Page number?
Page number 29, my lord. Page number 29. I fully appreciate what has fallen from your lordship. I am not praying for any benefit till the time, my lord, I paid the penalty.
No, on the page number 20.
Page number
20th
29.
October 2020 is a demand notice.
No, my lord, therefore you have directed. Right. Now, my lord, kindly turns over. Page 30. Rupees 4 lakhs debited from my account. That is an admitted position that I have paid penalty plus the extra royalty money. There is no dispute with regard to this fact. And page 31 kindly turns over, my lord.
On 1910.
Collection of royalty, page 31.
1910-2022.
Absolutely.
And how much time they?
Yes.
7 months.
Yes.
Oh.
Now, my lord, kindly comes to the order of suspension. Page 25. After I paid the penalty, you should have permitted me. But you withdrew after, again, I've delayed it for 7 months. How that is
Your
possible?
contention is that from the day of payment of
Absolutely.
penalty, they should have revoked
Absolutely.
the order of suspension.
Well, there cannot be double jeopardy, my lord. We can choose, my lord. That's the law is well settled. Not for the balance prior period, my lord. When they had issued it, that is, my lord, at page 25. I accept that. But after I paid the penalty, you should have given me the permission. You withheld it. How that is permissible?
Any report has been filed in this
Yes,
case?
they have filed the report and they have stated the same thing.
Which order is under challenge?
My lord, order is, lordship would kindly comes to, my lord, page.
Have you made any
46.
representation?
Yes, representation, then the final order. I did everything, even after.
Where is the final order?
Page 46.
Page number 46.
Yes.
Give me a second. Will you please, sir?
Yes, absolutely, my lord. I have heard the writ petitioner gone through his representation dated so and so regarding the extension of lease for the time which the petitioner was not allowed to carry on mining operation despite payment of penalty, the case records and relevant rules of the minor mill. I have seen the Honorable High Court Calcutta in its order dated so and so, which is the earlier writ petition, my lord.
Yes.
I must show you.
Yes. Skip that paragraph after careful consideration.
After careful consideration and scrutinizing all the relevant documents available in the file, it appears that the District Magistrate Makura had issued a suspension order to the petitioner, Vito Memorandum so and so, on 7th March 2022, based on a report received regarding illegal sand mining. Being an authorized officer under section 21 of the Mines and
Very good.
Minerals.
Next paragraph, sir.
I have seen the reply of the petitioner, then kindly comes to the next paragraph. Ultimately, on the basis of hearing dated so and so, which your petitioner, and after due consideration, District Magistrate realizing the penalty, suspension was revoked on 29th May 2025. Petitioner in his representation dated sensei, if he had deposited the penalty within the stipulated time, yet again the suspension was not immediately. He therefore prayed for suitable extension of the period. Now, what they have said, Miller, that there is no specific provision. That inherent power is there. How can a person be twice?
Yes, Mr. Banerjee.
That's my only contention.
Now, page 26 is his admission.
And one more submission.
Number one.
And one more. Just another point, Miller. Lease agreement, if Lordship sees, lease agreement, which is the paramount, when there is no specific provision, obviously the inherent power has to be invoked and the lease agreement will prevail. Lease agreement does not provide any clause of that nature that after I paid the penalty, they would linger it for an indefinite
Let
period.
Mr. Banerjee.
Absolutely. This is my point.
Yes, Mr. Banerjee.
Page 26, my lord, is the admission. He has apologized, but admitted that he has committed something, my lord, beyond, my lord, the provisions. And
no, Mr. Banerjee, let us come to the point.
Fine.
When he has paid the penalty,
My lord.
imposed by you,
My lord.
you ought to have revoked the order of suspension forthwith.
After payment, lease deed or the rule do not say immediately on the date it has to be. After payment, it was considered by the Milord district magistrate and order is passed. In the
No,
decision,
no,
the
order,
first term
page
time
number,
is-
please come to page number 29, Mr. Banerjee.
Fine.
Let us see what is there. Page number 29 is the order, no?
Yes.
Where such as a when on so-called notice was whereas submitted by reply,
The payment.
you are
Payment.
directed to deposit penalty of rupees 1 lakh from the date of receipt of the letter.
That is payment.
Otherwise, the matter will be dealt as per the deliverance. So, P has paid the penalty.
after payment of penalty, my lord, we have to take a decision. Penalty he has paid. Now,
After 7 months.
page 26 is not reply to show cause where he has admitted not illegal mining.
And 8
So
months.
after payment of penalty, we have to take a decision. It doesn't mean that the date when penalty is paid on that day itself you will.
Where is that decision?
No, decision was not revocation, which is not after a period of 7 months. So he says it has to be extended for that.
No, have
For
you
extent-
taken the decision that apart from penalty, he will be deprived from excavating the sand
He was
for a
permitted to
part of.
excavate. He was permitted to excavate.
Then it is
For
stopped.
that time was taken. Now,
It is
Milord,
that is the job.
for extension, Milord, there has to be a provision because if he is aggrieved by Milord the delay of 7 months, that is Milord a prayer for damage. At the most, he can Milord ask for damages against the state. There is a separate remedy. But for extension, there has to be specific provision because lease has come to an end in 2024 January. After that, Milord,
No,
he
it
has,
is because of your non-communication, Mr. Banerjee.
Milord, we have taken a decision. We have taken some time for the decision. Now, if Milord, that is not a
But
latches
that
on our
cannot be.
part,
That should not be.
that cannot
That
be-
should not be at the cost of the sufferings of the writ petitioner. No.
No, if a person suffers, Milord, for that, Milord, he can have a claim for damages. That I've suffered for this 7 months, I've suffered this amount. But another Milord, extension has to be as per the rules of the lease deed. He will have to show that as per rules is entitled to extension. Now the extension clauses normally in the lease deed says for force measure, any situation covered under force measure, if there is any delay for that period, they can get extension. Now he is saying inherent power. I am not a Milord court exercising section 151 that I'll exercise inherent power. Lease deed is the particular clause, force majeure clause, which says in those circumstances, war or Milord anything Milord which comes within that clause, extension can be granted. That Milord we cannot stretch to a situation where Milord they say that there is a delay on my part for which they will get extension. Extension can be only as per rules. This is number one. Secondly, Milord, as stated in page 9, paragraph 10, Milord, during pendency, he has already Milord refunded the bank, withdrawn the bank guarantee.
Which
Now,
one?
we
Which one?
finally come to page 9, paragraph 10
Of
my report. Of my report. So, first submission is
page number.
page number 9, paragraph 10. I further state that while the instant petition is pending before the Honorable Court, petitioner submitted a prayer on 30th August 2024 seeking refund of the bank guarantee, which was deposited for earlier mining, as expired on 15th of January 24. Accordingly, prayer was allowed and the said bank guarantee amounting to 18,73,000 has been released by the respondent. So he has already withdrawn the bank guarantee also. Had he Milord a claim of extension, how could he have not withdrawn the bank guarantee? This action itself Milord shows he has withdrawn the money and he is trying somewhere else. Number one. Secondly, Milord, there is no provision, Milord, which permits Milord extension. Only remedy can be by way of damages. And thirdly, Milord, he has admitted his guilt, for which Milord we said him to deposit the penalty. He has deposited. Authority has considered, taken a decision. For that, there may be some delay, but that will not give him a corresponding right to ask for extension. This is my submission. And the order, Milord, speaking order, Milord, says the same thing, that the rules of the lease deed do not permit extension. This is not the forum, Milord, for not getting an extension merely because Milord, there was delay. Only remedy is damages.
So I will add only 2 points. If your lordship kindly come to the order of suspension. In the order of suspension, the direction was upon the petitioner to deposit within 7 days. He deposited after 7 months.
এই একবার দেখে নাও না ঠিক আছে একবার দেখে নাও ভুল বলছো বোধহয় 20 তারিখ
7th March.
না দেখে নাও পরের পাতাটা দেখো গন্ডগোল হয়ে যাচ্ছে পেজ 29 আর 30 দেখো
25 এ কি বলছে?
গন্ডগোল 25 হচ্ছে is the notice 25 does not say গন্ডগোল হয়ে গেছে তো
Sorry, it was asked to show cause within 7 days. So I stand correct. And the order which is under challenge, this is an appealable order in terms of Rule 51 of the Minor Mineral Concession Rules 2016. Sorry, it was the show cause within 7 days. Ashut.
My lord, just two things, my lord, in reply. Just two things if Lordship wants. Number one, my lord, Lordship knows point of appealable orders. Alternative remedy, my lord, if there is no bar starting from Whirlpool, several judgments, if the perversity can be shown on the face of it. I say this is a clearing case of perversity. Number one,
Perversity is
please,
wrong.
একবার অয়ন বলে নি, তুমি বলেছো। আমার submissionটা করে নি। Number two, what does it say, my lord? He says there is no specific provision. Now, my lord, to that answer is, my lord, where is the bar, my lord? Is there any specific bar provided in the statute? Law, my lord, says, my lord,
Take down.
unless something negative is there, my lord, it's not
This
my
court
own.
has heard
My lord, may I, my lord, take back the copy?
Much obliged. With your kind leave, my lord.
Next. Who's for the petitioner? কোথায়? দেখি দি। 6 কেউ নেই?
Your lordship, give me passport.
Lord, I appear for the state respondent.
Your lordship,
Who is the leading counsel?
Devashish Chattopadhyay.
Devashish Chattopadhyay is your friend.
Sir, I'm a senior.
Then say Mr. Devashish Chattopadhyay, sir. Madam. Pass over.
My lord,
12 o'clock.
12 o'clock.
My lord, I'm for the petition.
When I'm for the state respondent, Lord, I have already filed my report and copy of the report has already been served on you.
Let me see what is there.
We also filed exception to the report and submitted. My lord, the case of the petitioner is that, my lord, in the year 2018, an auction was held. The petitioner participated in the said auction and became the highest bidder. Thereafter, the petitioner deposited 1/3 of the bid amount, that is approximately 14,04,000 rupees. And thereafter, LOI was issued in favor of the petitioner. Petitioner applied for seeking environment clearance before the respondent
You have
authority.
deposited 1/3 amount, thereafter LOI was issued.
Yes, ma'am.
Very good. Thereafter, what happened?
Thereafter, my lord, the petitioner made applications seeking environment clearance. The last application which was made by the petitioner was on was on 16th March 2022, Annexer P8 to the writ petition, my lord, page 28. To that regard,
Page number 28.
Page number 28. To that regard, a receipt was issued.
Page number 28. What? Let me see what is there. It was hard earlier.
Yes, it was hard.
It was hard.
And your lordship directed me to file the report. I put the objection. Why he cannot be given? Your lordship, if your lordship so allows, I can place my case, not my report.
Just a minute, sir. Let me see.
It was already hard. And upon hearing the petitions and my submission, not counter submission, your lordship directed the state authority to file the report in the form of an.
Very good, understand. What is page number 28, sir?
Page number 28 is the acknowledgement receipt.
Acknowledgement issued by whom?
Acknowledgement regarding, my lord, we applied before the SIA seeking environment clearance in the Porivesh portal, and to that regard, page number 28. Page number 28 is the acknowledgement of such representation. Thereafter, my lord, the application was kept pending, and that is why, my lord, we preferred an original application before the Honorable National Green Tribunal, and Honorable NGT passed an order. At page 32 is the operative portion, my lord, paragraph 9. We therefore, may I place it, my lord?
Yes, sir.
Page 32, my lord.
Just a minute, sir.
Para 9.
Page number 32 is the order.
Operative portion of the order, my lord. Order starts from page 29. Page number 32, para 9.
Yes, sir.
We therefore dispose of this original application with a direction to the SIA West Bengal to examine the issue that when the DSR is not available and the decision has been taken by the SIA West Bengal to delist all application through their resolution order passed in a meeting held on 27 December 2021. How could the Government of West Bengal, Department of Industry, Commerce and Enterprise, Mines Branch, Government of West Bengal pass an order dated 17 February 2022, which is contradictory to the stand of SIA West Bengal and against the decision taken by the SIA West Bengal? We find that this letter of Government of West Bengal, Department of Industry, Commerce and Enterprise, Mines Branch has been marked to the Member Secretary West Bengal PCB and Member Secretary SIA West Bengal. We also direct the SIA West Bengal to take a decision in the matter wherein within 1 month, specifically referring to the order of the Government of West Bengal Enterprise dated 17th December 2022. And in case the DSR has not been prepared, appropriate direction shall be issued to the Government of West Bengal, Department of Industry, Commerce and Enterprise Mines Branch not to invite bids in the absence of DSRs in the respective sand blocks. However, if the DSRs have been prepared and approved, then bids can be invited for sand block mining. The SIA West Bengal shall consider the application of the applicant dated 16th March 2022 and pass appropriate order in accordance with law within 1 month. A copy of this order may be placed before the Chief Secretary, West Bengal, to inquire as to why the Department of Industry, Commerce and Enterprise are auctioning sand bids in the absence of appropriate DSRs, as the DSR forms the basis for application of environment clearance. Thereafter, my lord, at page 51 below portion, my lord, 64th ACSC meeting was held.
Page number 51.
51. Operative portion is at page 52, my lord.
Just a minute.
Page number 51 is the... No, my lord. Page 52, my lord. Page 52.
Yes, page 52.
My lord. Below portion H. This is the proposal of your petitioner, my lord. Project proponent Sri Basudev Maji. Thereafter, page 53, the observations laid down therein. The PP did not engage any NABET accredited environment consultant and appeared for the EC presentation. Second point, my lord, based on the submission and presentation.
Let's be point number 1 first.
Yes, my lord. The PP did not engage any NABET accredited environment consultant.
Oh, activity, point number, why are you so hurry?
Activity.
Page number 52, got it, activity?
Yes, ma'am.
Place 1 by 1.
Okay. This is a proposal for riverbed sand mining at the Raina.
Such and such, yes.
Such and such.
Then?
Thereafter, my lord, the mining cum progressive mine closure plan prepared according to the provisions of the West Bengal Minor Mineral Consensus Rule 2016 for riverbed sand mining at the site over a leasehold area of such and such, my lord. Paragraph 3, point 3. It is mentioned in the mine plan that there is a mineable sand reserve of 42,000 m3, which the geological reserve is such and such. Thereafter, my lord, the PP has not uploaded the pre-feasibility report for the proposed project. Thereafter, the PP has uploaded the approved mining cum progressive mine closure plan. The PP has not uploaded valid LOI, original LOI mentioning the plot number, showing the exact location and cluster certificate from the competent authority. Thereafter, my lord, chronology of the event. The PP applied in prescribed format for environment clearance and uploaded the application in the Porivesh portal on 26 December 2022. The PP was called.
What the PP stands for?
Project proponent, my lord.
Project proponent, you?
Yes, my lord. The PP was called for the environment clearance presentation in the 64th ACSC meeting held on 1st February 2023, and the PP presented their proposal in this meeting. Thereafter, my lord, the observation is that the PP did not engage any NABET accredited environment consultant and appeared himself for the EC presentation. Based on the submission and representation made by the PP, the ACSC observed that the plot area for the proposed project, as reported in the approved mining cum progressive mine closure plan, does not fall within the potential mining zone recorded in the approved district survey report of Purbo Bardhaman district. Also, the PP has not uploaded valid LOI, original LOI mentioning the plot number, showing the exact location and cluster certificate from the competent authority, and other related documents, my lord. To that extent, my lord, the petitioner submitted that.
The committee therefore recommended the proposed project is cannot be considered. So you have not received the environmental clearance.
Yes, my lord.
I
This is
have
the
not-
crux of the matter.
I have
That
not
is the
received
crux
the
of the
environment clearance.
Because of your lacuna,
Yes,
it cannot be done.
on the last day are good, and this is the crux of the matter.
No, my lord,
Only this point.
I had made several applications before the SIA seeking
And
environment
this is
clearance.
his keeping of.
SIA, who is the appropriate appellate authority against the order of the SIA? Green Tribunal.
Yes, my lord, we preferred original application in the Green Tribunal.
No, on the basis of the original application, the CA considered your application.
Yes, my lord.
And they have come
rejected
to
my
a
proposal.
finding that they cannot recommend on account of such lacuna.
Right.
So what is the wrong?
No, my lord, if the plot does not fall in the potential zone, my lord, that is not my fault, my lord. I had participated in the e-auction process and became highest bidder. The government is the authority as per Rule 5 of the.
No, the PP did not engage in
No, my lord.
NABET accurate environmental
The
concept
NABET was-
appeared himself for us to
NABET-
based on
NABET
the submission presentation made by the SSC observed that the plot area of the as reported in the does not fall with. So you have to produce the document.
My lord,
Exactly
nobody
correct,
can
my lord,
part.
what your lordship rightly held it.
My
On
lord,
the last occasion, I argued this point only. This is the crux of the whole matter.
Allow me, my lord. First of all, the auction total issued by the district authority. We are the general public, we participated in the auction process. Secondly, we become the highest bidder. We have got the LOI, letter of intent, after deposit 1/3 bid amount. Main basic principle of the grant of LOI or auction process, prior to that, the authority has to examine the plot, then they will advertise the plot for auction under Rule 5 of concession rule. Auction. They did not comply. Entire 460 lease has already auctioned by the district authority in the West Bengal. All are suffering in the same earlier on last Friday. My lord has also passed an order and another matter directed the SIA to reconsider the application of the petitioner. Here, my lord, they have taken 3 points for delisting the application. Kindly allow page 52 further, my lord, the observation of the Green Tribunal that without making any DSR, without any availability of land, they have auctioned and snatch money from the public. And total investigation for that, my lord, the Green Tribunal directed to Chief Secretary to make inquiry regarding this matter. Environment clearance also issued by the government. We can apply only. The project proponent can apply only. There are some authorized person, they can prepare the total project and apply by the portal. Why is our fault, my lord? We have invested money, that is our fault.
You get the
Please
environment.
come with the report. Kindly see their report also, my lord. Kindly consider our supplementary affidavit
As
after
reported
filing
to
this
the-
deed application, my lord.
As reported to the approved progressive mining.
Kindly see, my lord, the supplementary affidavit also, my lord.
No, sir. Read this one. Progressive based on middle portion, page number 53.
Yes.
Based on the submission and presentation made by the PP, the ACAC observed that the plot area for the proposed project,
Yes.
geo coordinates,
Yes.
as reported in the approved mining cum progressive mine
Yes.
closure plan,
Yes.
does not fall within the potential mining
Who is
zone
liable? Who is liable, my lord?
recorded in the approved district survey report.
Who is liable, my lord?
Potential
Why they have
mining zone means
issued the notification for
potential
inviting
mining
tender
zone
notice?
means from whence and cannot be
Who is liable, my lord?
potential mining zone. He
Who
does
is
not have
liable
that.
for that?
He has to have the clearance certificate.
We are not.
He does not
We have not invited for an
64th
tender
meeting,
process, my lord.
clearly, blood, 64th meeting, I have to read in its entirety. Besides that, blood, I am submitting, I have.
I'll allow you, Mr. Ganguly.
My lord.
Who is liable for that? Total auction
No.
process has been
Approved
conducted by
mining
the
cum
state
progressive mine closure plan does not fall within the potential mining zone recorded in the approved DSR. So DSR has been approved.
DSR subsequently approved here, my lord. First of all, the process is first DSR has to be approved, then tender process has to be conducted by the authority.
Where is
Here,
that
my
finding?
lord,
Where is that finding? Where is that finding?
kindly allow me, my lord, rule 5, concession rule, my lord.
দেখি দিন এই কনসেন্ট রুলটা
Auction rule.
My lord, may I assist, my lord?
এই দিচ্ছ
এই জজ সাহেবকে দেবেন না এটা?
হয়ে দে, দেখা। Auction rule টা বার কর না।
এখান থেকে বার করো, কোথায় দেবেন? পরে
ওয়েস্ট বেঙ্গল মাইনর মিনারেলস কনসেন্ট রুলস
Auction rules 2016, my lord. Page 108. না, এটা মিলবে না। কারণ আলাদা।
রুল কি এখানে আছে কনসেশন রুলস
এর minor auction rule 2016.
অকশন রুল ইজ দেয়ার
আমি জানি
পেজ 99
সারা রাত খোঁজা 7 দিন খোঁজা আমি জানি
ইয়েস
Rule 5, my lord. Pre-requisition requisite for auction of mining lease.
হ্যাঁ
The district magistrate of district may initiate an auction process on behalf of the state government for grant of mining lease with respect to an area with his jurisdiction if the mineral contents in such area have been established and notified. The district magistrate shall to prior to issuance of the notice inviting tender with respect of minerals auction, identify the demarcate and the area where a mining lease is proposed to be granted through auction by using total station and differential global positioning system, and the area so demarcated shall be classified into forest land, land owned by the state government, and land not owned by the state government. The total liability upon the government, my lord.
yes but where from will get that based on the submission and presentation made by the PP
Yes, my lord.
the
Kindly see
SCSE
page-
also that the plot area for the proposed project geo coordinate as
Plot is not
reported in
within
the
research
approved
area, my lord.
mining camp progressive mine closure plan does not fall within the potential mining zone
They totally violated the rule 5.
recorded in the approved district survey report.
Yes. That is duty of the authority, my lord. The whether plot is within the DSR or the mine that can be mineable or not. It is not a private property. It is the property of the government, my lord.
Where is the order of the
Then, my lord,
just a minute sir is 32 টা দেখাচ্ছিল না
West Bengal Mineral Development Corporation, for which Mr. Shah is appearing, they should have been implemented. They have also not been made party in this application. On the last day, I submitted before my lord.
district authority issued the auction in the year 2018, and Mr. Saha is the Mining Mineral Development Corporation.
the party
No, they have not been made party.
Because, my lord, the
West Bengal
entire notification
Mineral Development Corporation,
government
for which
notification
Mr. Shah Sanjay Shah is appearing. On the last occasion was I requested my lord that they should have been implemented in this. They are the answering respondent, one of the vital respondents.
yes,
They
we
have
can-
not
we
been implemented in this
kindly give
application.
liberty, we can
They could have
made
come
him
with
party,
their
but
at
my
the
lord,
stand.
Made
our
him
problem
party.
cannot be solved by Mr. Saha
They
because,
should
my
be-
lord,
Yes,
My lord, I am
kindly see the document, my lord, issued by the commercial industry.
they are required to be made party in this application. They are
Yes,
the
yes.
primordial
Give liberty to-
primordial answering respondent because
I am present here, my lord, West Bengal Mineral Development Authority, my lord,
Yes, yes.
led by Mr. Saha, my lord.
Yes.
is a party to the proceeding
No, no,
They have not been made. Willingly
See
they
the
have not been
notification, my
made
lord,
party.
why we did not made him party?
They have to
Kindly-
come with their
no
stand.
no come made him party
Yes.
They should come with their stand, Lord. Because
Liberty is
the
given to the
2016 rule specifically said
liberty is given to the writ petitioner Let me come back. Let Mr. Saha come back. Mr. Saha and Mr. Mondol. এটা উকিল ওকে এখন দিয়ে দাও, এটা আমার এখন লাগছে না।
Lord, may I take back the book?
Yes, sir.
Yes. Grateful, your lordship.
May please your lords. Well, pursuant to lordship direction, June 9, my lord, I have served copy of the claim has been served, but they have received. From morning, I am before your lordship because they bit of service. The lordship they have received, my lord, on 17th, they registered on 18th, they have got it. After appeal question.
My lord, I am appearing for the response number 3, my lord. I am appearing for the state response.
Very good.
Now, my lord, the issue is very simple. I have got certain the petitioners, the owners of certain landed property. They have that has been required by the government for installation of gas pipelines. You kindly look at page 18 and 19. There are the two brothers. Jagdishpur, Holdia o Bokaro Dhamra gas pipeline এবং স্পার পাইপলাইন প্রকল্পিত জমি ব্যবহারকারী অধিক নিয়ম অনুযায়ী 1962 3 নম্বর ধারা 7 they have given the description of the land, but we have no objections because they are entitled to install, but regarding compensation they have fixed with lower rate. We objected because the position is going on. They have fixed only, my lord, for such huge amount of land. The two brothers have been offered 7 lakhs and odd amount. But my lord, here for 1 decimal only it is now selling 3.5 lakhs. That's why we raised objections that you make proper calculation and pay us. Another thing, my lord, the plot number 1338, the land is, my lord, larger area, where we requested that the gas pipeline should be diverted without going through the middle of the path, middle of the land. We should be relocated by the.
So let them take a decision.
Take a decision. You know, DL is the on the last.
Who is the appropriate authority to take the decision?
District authority, madam.
District authority is the real authority. Because, my lord, the district.
So for the compensation concern, my lord, statutory appeal is there, my lord. It has to be decided by the district judge.
No, that is in case of land acquisition. The competent authority, land acquisition officer.
No, what is your prayer then?
Prayer, my lord, the certain gas pipeline through the land, which is through land plot number 1.
No, the land has the pipeline has been laid over the acquired land.
No, it is my land has not been acquired. For, my lord, the installation of pipeline, they require the land. Kindly look at page 18.
Yes, sir.
So they will install. They have installed. But in respect of
it is for the purpose of user.
Use.
It is for the purpose of user. জমি ব্যবহারের অর্জন করা আবশ্যক. Very good. Then what happened?
Then, my lord, but they have given the
for using your line, for using your land, they paying compensation.
They are proposing to. Can you look at page 9, paragraph 9? They have, my lord, proposed 7,79,040.
Paragraph 9.
Paragraph 9. That amount is, my lord, too low. Because what they are causing damage, in the ratio of damage, the compensation should be higher. At least, my lord,
no, who decides this amount?
Hello?
Who decides this amount?
This amount has been decided by the district collector, land acquisition authority.
Under which act?
Under this, my lord, this is the act, this is the position.
What is the act?
My lord, may I submit on this is, my lord, according to section 10, subsection 2 of the Petroleum and Mineral Pipelines Acquisition and Right of User in Land Act 1962, district judge is the authority to determine the quantum of compensation. District judge is the authority.
And if a person is agree with the quantum, what can be done? What is the remedy?
District after appeal is final, my lord. Thereafter the writ.
Sorry?
Appeal is final.
He has to approve
Appeal
it
is
before
final.
the
After
district
appeal,
judge.
he has to file the writ before.
Appeal.
Lordship. That firstly, it has to be decided by the collector, my lord.
That I intend to know.
If he-
Thereafter,
if
if a person is agree with the quantum, then what is the remedy?
Then
He
start
has to
appeal.
move-
Appeal, my lord.
Appeal before whom?
Appeal with the district
District
judge.
judge.
So,
District judge.
show me the law, sir. What is the act?
My lord, that is not with us, my lord. May I?
That is in case of
Come back,
permanent
my lord.
acquisition irrigation.
With
Here they are
appropriate-
not taking my lord.
And the
with
other
appropriate
day,
instructor,
two
my lord.
matters were disposed of. I have shown your lordship the act.
Huh?
The Gale authority was also represented.
Huh, Gail is there. Gail is here.
Gale is here also.
Yes.
They should produce the act, my lord. Appeal is provided, and your lordship has held in two matters that
What is the name of the act?
The mineral and pipeline.
The petroleum and
Pipeline
mineral
acquisition-
pipeline.
Mineral?
Mineral and
No, no, no,
pipeline.
no.
Pipeline acquisition of right to user of land.
Mineral.
1960.
Just a minute. Mineral and pipeline.
Firstly, petrol and
Petroleum.
mineral. Petroleum
The
and mineral.
petroleum and minerals pipelines.
My lord, in page 18, it is there. Page 18. এই পাইপলাইন বসানোর জন্য
Sir, I want to know the name of the actual
That
name
is
of
the
the act.
ভারতের ঘোষণা পেট্রোলিয়াম এন্ড মিনারেল পাইপলাইন
Just a minute.
পেট্রোলিয়াম
And minerals
and Minerals Pipelines Act 1962
Yes, I got it. Just a minute.
1962 সালের 50 সাল 3 এক ধারার অন্তর্গত
instruction ডাউনলোড করতে পারো না একটা ভিডিও করে নিও
If the amount of compensation determined by the competent authority under subsection 1 is not acceptable to either of the parties, the amount of compensation shall on application by either of the parties to the district judge within the limits of whose jurisdiction land or any part thereof is situated be determined by the district judge. So go before the district judge, sir.
Yes.
There is a provision for appeal.
that is one aspect. Another aspect, my lord, the pipeline which was installed through plot number 1338, that should be relocated because it has gone straightway through the portion of the land.
How do they change the alignment? On what basis?
My lord, installation of pipe, they can relocate it. It is going in this way, it will go by the side of the plot.
in my lord WP number 6645 of 2025 Sumita Pal versus Union of India. I appeared, your lordship has my lord holding that appeal is provided, no relief is given.
That I am saying.
6645 2025 Sumita Pal versus Union of India.
So if you do not come with the book, how can it be done? Asu. The writ petitioner
At least they would consider.
No, no, why should they?
Very good. One
And my
matter
lord-
was fixed at 12.
One second.
My lord, one matter was fixed at 12.
My lord,
Yes.
the amount of
Pass over matter. Item number 6.
My lord, 1 second. My lord, the amount of compensation which they have already given, we may withdraw the same without prejudice to our rights and contents.
So who am I to obstruct you? No, nothing.
After a few minutes, I am giving the affidavit service.
Which for the petitioner? You will argue.
আপনি যা petitioner হয়ে
My lord, the petitioners before your lordship are the owner of 60 total altogether 63 decimals of land within Mauja.
Give me a second, sir. এই উত্তমকে একবার ডাকুন।
Yes. Now, my lord, the petitioners before your lordship are the owners of the total 63 decimal of land within the block Chakda, district Nadia, Mauja, Shoguna, and lordship will find all the deed of title and the porcha in respect of all the altogether 63 decimal of land at page 40,
What is the total quantum? 62.
63. Lordship will find at
63
page
decimals, yes.
41. Page 41.
All the petitioners are the landful owners of 60 within the Mauja Saguna. Yes.
Lordship will kindly take page 41. Lordship will get the porcha from where it will be evident that they are the owner of the 63 decimal of land.
Page number 41.
43, 41.
41 তো দলিল
না
pages are not telling.
দলিলের সাথে আছে দেখুন দলিলের পর
এই তো 39
Yes. Page 2, paragraph 2.
এই দেখো না ফাইন প্রিন্টটা দেখো ভালো করে দেখো কি করেছে এই যে পর্চা এখানে চলে গেছে
চলে গেলে কোথায় করবো
তার কি বড় কাজে যোগ হয়
0.6
সরি
no issue.
Yes.
Sometime in the year 2008, the Public Health Engineering Department started inspection for the land for installing a project for supply of arsenic-free water, drinking water. And accordingly, my lord, they approached the petitioner for their consent because they have selected their plot. And lordship knows that in terms of the act, the petitioners have to give the declaration in the form of Ongikar Patra. Lordship will find at page 42.
একটু ফ্ল্যাগ দিন না ভাই। আমার জমি মূল্য গৃহীত না হয়ে আমাদের উত্তরাধিকার প্রকল্প নির্মাণের ক্ষেত্রে কোনো বাধা দিব না। এই কার্যের জন্য আমাদের উত্তরাধিকার সরকার নির্ধারিত মূল্য গ্রহণ করিতে বাধ্য থাকিব। Yes.
This declaration arose out of a LA case number, Lordship will find at page 43, LA case number 58 of PHE 2009-2010, page 43. My lord, in the second paragraph, it is stated the said notification under subsection 1 of section 4 of the Act has also been published in the Times of India on 5/11/2011 and Ajkal Patrika on 4/1/2011 and in Ganashakti on 5/1/2011. So, out of this LA case number, these Ongikar Patra have been taken or the declaration have been taken. My lord, since there were 3 plots, so 3 numbers of notices were given. Page 43, 44 and 45.
LA case numbers are same.
All the LA cases number are same, notices at the difference on the same date.
Plot numbers are different.
Plots are different. All the plots are different. RS plot number 138.
Plot numbers are also
Plot number the same. Plot numbers are same. Actually, these 3 plots were purchased by virtue of a 3 different sale deed on different dates.
Be there as it may. What happened thereafter?
Then, my lord, kindly come page 46. Notice is hereby given. May I place it? Page 46. Notice is hereby given that 0.2549 hectares, that is 0.63 acres, more or less, of land situated in or near the Mauja Soguna jurisdiction, jail number, jurisdiction list number 80, police station Chagda, district Nodia, described below, and recently marked out and measured, are about to take in a government for construction of surface water based water supplies scheme for arsenic affected areas of Chagda block and Horingata block such and such, in accordance with the declaration dated such and such, published in Government Gazette number 8/6/2012. The date of declaration under section 6 of the Act is 8/6/2011 This is most important. So the date of declaration is 8/6/2012. Now thereafter, my lord, kindly come. The award, when the award was published.
এই Act 30টা বার করুন তো ভাই। 30/2013.
No, my lord, it should be under Act 1.
Act 1.
No, I want to see that also. Act 1টা বার করুন। Act 1 Land Acquisition Act, এটা পাবো। আর এটা বার করো না। নতুন একটা নতুন। Date of declaration. Date of declaration is 8/6/2012.
12.
না আমি বলতে চাইছি ওই যে ল্যান্ড অ্যাকুইজিশনের নতুন বইটা, হ্যাঁ ওইটা। Yes.
Now thereafter, kindly see the lordship, kindly see the award.
Page number?
Page annexure P5. Lordship will find at page 49 onwards. Page 49 up to page
54. My lord, in respect of one plot, the award was 11,000, 1,16,706. In respect of page 53, $35,012.
Just a minute, sir. In the name of whom? Who is the awardee?
My lord, the award is the petitioners, 1,16,000 in the name of Ganesh Haldar.
Khapon Haldar.
No, Khapon Haldar is there, but if you also kindly take page 50. But at page 49, the three names have been given. Khapon Haldar, Kartik Haldar and Ganesh Haldar.
Swapon Kartik Ganesh.
Yes. Khapon Haldar, 1,16,705.
All have got same.
Same.
All have got 1,60,000 each.
705 rupees, such and such.
Very good. Then what happened?
Then, my lord, kindly.
Then what is that page number 53?
Page number 53 is the
12 to notice.
12 to notice. Now, Lordship.
Just a minute, sir. এই আমার ওটা পার করো না ল্যান্ড রিফর্মস এর না এই না 1894 টা এখানে নেই এটা
May I hand up my book?
Yes, sir, give it. Chapter notice টা করে দিই। Yes, then what happened?
Then, my lord, since the award was not accepted by the petitioners, they took the market value of the entire property, obtained the market value from the registering authority of the properties, and by annexing the market value, they raised their objection before the collector. Copy of the have been submitted to the PTO, the district magistrate, and this was submitted in the year 2012. Lordship will find page 55, objection. Thereafter, before the district magistrate at page 59.
The matter was referred to the elect tribunal.
No, nothing. My lord, all objections have been raised, but that has not been disposed of within a certain period of time as per section 11A. Now, the peculiar thing is this, my lord. After 2012, no steps have been taken till 2025.
No reference was made under section 18.
No.
Have you make any application for reference?
No, my lord, after 2012, since they have not,
No.
no.
You have received the 12-2 notice.
12, yes.
Thereafter, have you made any application for making reference
No.
to the jurisdictional court?
No, nothing. We have not done.
Then?
Not done, madam. Now, presently, after in the year 2000, just 1 month ago, the officer of the PWD forcefully entered in the plot. No project has been started. The land has still vacant. No, forcefully entered in my land and hang up a notice board. My lord, this is I have taken the photograph. If your lordship.
No, I will let us discuss a law point. When acquisition under Act 1 of 1894 become complete. On the publication of the award?
Yes.
And you have received the award of the
After
collector when to be
publication-
final. Such award shall be filed in collector's office and shall accept hereinafter provided be final and conclusive evidence as between the collector and the person interested, whether they have respectively appeared before the collector or not, of the true area or value of the land and the apportionment of the compensation among the person interested. The collector shall give immediate notice of his award to such of the persons interested as are not present personally or by their representative when the award is made. Matter is end. The award becomes final.
But no award has not been award. They have published the award, but thereafter, after taking we have not accepted their award. Therefore,
then you have to make an application for reference.
That they have that is the proper point of issue.
You have to made an application before the registering magistrate for making the reference. And when the district court having determination for having jurisdiction to decide whether the
Section
notice
18 has not been complied with.
Then what can be done?
Then, my lord, I'm withdrawing this writ petition. Liberty may be granted to approach.
No liberty is.
No liberty.
No,
Not, at this stage, it cannot be done. Asun.
বইটা একটু দেবেন না?
এই উকিল বাবুকে বইটা একটু দিয়ে দাও গো। আমাদের কাছে
দাদা দাদা I am for the stand. I am. Lord.
But, sir, my lord, there no.
Yes, yes.
Happy to be service, my lord.
I am for this.
I am for the core petitioners, my lord. May I, my lord?
Point number 6 and 10.
Men.
You are the answering respondents. Yes, sir.
Malad.
That's your case.
But petitioners are malad, the owners of certain plots of land, malad, the colliery land, malad, underneath the colliery, malad. And they are having lands more than 1.09 acres of land, and it's the informal sleep also. By this instant petition, malad, I am challenging the order impugned, malad, at page. What happened to 204 to 211, malad. But that order impugned, but that is a hearing done by the respondent number manager, general manager.
area.
Yes. 104. That has been done, pursuant to the order. Pursuant to the order given by this honorable division bench to cause for a hearing, and that order kindly come to at page 154 to 157 P17. That is the order of the division bench.
Page number 154 to 157.
May I place some checker history,
Yes.
This ECL took land for open cast quarry for extracting coal, which land after being subsided, totally subsided, and has been permanently damaged. Petitioners having approached the authorities of ECL authorities for getting employment under the land loser scheme, and having approached the High Court earlier, this is the fifth time, with a claim which was rejected earlier. On the ground, the authority neither purchased nor damaged. I pause here for a moment. Kindly come to there's an agreement between the parties. Kindly come to page 59 once. It is very important to read out the agreement to your losses, Agreement though 3rd of February 1979 between ECL and the parties, My predecessor interest was at that time was there, And I am reading, I'm skipping some few lines from the top, which is usual parts of the agreement. Whereas the second party is the owner of the land, and whereas I'm reading the losses from the middle, and whereas the owners had been in exclusive possession of the said land by cultivation, and the said land has been recorded in the name of the owners in the RS record of right, and whereas the surface of the said land have subsided to a little extent and have developed cracks therein due to depillaring operation undertaken by the company beneath the said land, and whereas the company requests the owner to grant the company to use of those surface land for a period of 3 years, starting from 1/1/75 to 31st 12/77, and allowed to use the said land under fencing, and whereas the owner has agreed such proposal of the company divided. I'm skipping now. Next one is between the there is agreed on by and between the following parties. The company agrees to pay this amount of the crop compensation. I'm skipping that amount also. Then kindly come to page 2, clause 2, second line in the next page, page 60. That the owner hereby declared that he is absolutely seized and possessed of the said land and is absolutely cultivated to transfer, convey, and dispose of any interest therein in or to grant any liberty on license in respect thereof to the company, and that the said land is free from any charges, lien, or encumbrance. Next clause, that the owner hereby agrees to sell permit and company the undistributed and exclusive use of the surface and for the said plot of land throughout the durations of the agreement as stated in clause 1. Next clause number 4, that for the land mentioned in the schedule below and for the said consideration, the company pay the owner some of rupees is done crop compensation. And next matter, I'm coming reading with the losses clause number 5, somewhere middle matter, that the owner had handed over the possession of the said land mentioned in the schedule below to the company, and the company takes over possession and of the same, and the company will have from today the absolute right and liberty to use the said land fenced to cut drains, to make embankment, or to carry out any other works as may be required by the Department of Mines to ensure that safety of the mines, etc., against depillaring operation, or under any other land which are in force at present, or it may be in force in future, and the owner will have no right to interfere or obstruct the same in the way or manner whatsoever during the duration of 3 years as agreed
So
upon.
for the purpose of depillaring operation, you have been
So
you have given the permission.
They have taken the land for quarrying also. But kindly come next line that the company expects that the depillaring and the subsistence will be completed within 3 years, and agrees to release the land, which is never done. In the event the company does not release the land after 3 years, it would pay such compensation the owner as may be agreed upon. Next clause is very important, clause number 7, my lord. I'm reading with a lordship. Accepting the payment as mentioned there herein before in clause number 4 of this agreement, the company will have no responsibility of any other payment, excepting, I pause there, excepting that in case any particular portion or piece of land is found with a very exceptional, unusual, and irregular subsidence, resulting in a well like a very wide depression, commonly known that this is should be commonly known as Hoska, making the leveling of the said piece of land impossible. The company shall purchase the said land and the piece of land only on the then market rate, as well as he undoubtedly settle the land between the parties. But in case the company purchaser, this is the common clause, execute. I'm agreeing, execute, my lord. Then, my lord, such is the case, my lord. I approached the authorities several times, my lord. There was a first petition to consider my representation.
No.
Consider and kindly bear with
That agreement, what happened to your land?
No. My agreement, my land has totally depressed. In depressed condition. Hoska is, but kindly come and I'll
It has become a Hoska.
Yeah, I'll cut short the matter. There are several litigations, but I could not. Kindly come straight away to annexure P9, page 104. Upon my representations, this was given to myself, my lord. Subsidy Mukhopadhyay, advocate, my lord.
104.
104, annexure P9. This is a very important admission on the part of this ECL, my lord. Given by area personnel manager, Kunusturi area.
Yes.
This is in reference to your email dated such and such in the matter of notice of Sri Subsidy Mukhopadhyay, Advocate, High Court, Calcutta, in the above matter. Subsequently, General Manager, Kunusturi area, constituted committee comprising of Sri P.K. Shah, Senior Manager, such and such area. And the detailed report is enclosed herewith for your ready reference. Next page, my lord. Subject committee report in respect of representation of our clients' names are there. As advised by General Manager, such and such, these are the people who were there. The legal matter in respect of the claim of compensation of such and such.
Kulanu.
From the then, Maharaj, there is the chart is there, Maharaj. Our land is there, serial number 1, 2, 10 is there, plots numbers are there, 7, 8, 9, 11, 23, 24. These are the land, Maharaj, and then, Maharaj, how much area. Then, Maharaj, number 3, a field survey was conducted by the survey team of Amrit Nagar Colliery to find out the physical status of the above scheduled land. Following other observations. What are the observations? These are very important. The plots mentioned in the above land land schedule are located above panel number 5 of Nega and Kajora, Jameseri, Seam. These are the related terms, they use of Damoda unit of Amrit. From the old plan and record, it was found that the panel was walked in partial caving method. The date of starting is 72 and sealing was 97. The mine in Damodar Colliery, presently under Amritnagar Colliery, was closed on 1982 due to fire. Next plot, my point is very important. Point number sub point 4. Subsidence occurred over the panel number 5, entire 5, shown in the enclosed plan in marked as A. Field inquiry shows that the subsidence affected only plot number 1123. Total area of 11 plot number 1120 is 1.06 acre and plot number 23 is 0.22 acres. Next page, my lord. Measured area of subsidence within plot number 1123 is 0.14 acre. No subsidence occurred in other plots, that is plot number 7, 8, such and such. That is, subsidence occurred land damage in an area of out of total claimed of the acre over 0.14 acre to total claimed of 3.
Subsidence occurred in plot
Yes.
number 11 and plot number 23
and they have stated
the extent
how
of
much
0.14 acre.
Yes, that has been. This is the admitted. This has been admitted by their memo on 9th of May 2017. And my lord, relying upon this memo, I moved to the Honorable High Court again, my lord. That was dismissed. Page number at page, my lord, 152. Page 152. That was dismissed.
Number.
I preferred, my lord, a mandamus appeal.
Sir, wait.
Oh, retrievable, no? This is page 152, my lord. This was dismissed as because of.
Wait, sir.
Sorry. I'm sorry. Deeply.
Sir, let us come back to page number 106 once.
106. Yes.
Measured area of subsidence within plot number 11 and plot number 23 is 0.14 acre. That is 14 decibel.
Yes.
Your land falls in that area.
It is. Entire panel 5. Now, my lord, at present.
How can you say that?
This is their admission on.
No, your land falls within plot number 11 or 23.
Yes.
To substantiate that, what do you want? What document do you have annexed?
Record of right. Page 54.
Plot number 11 and 23.
Yes. Is there? And then kindly can in Montobo column, Kua.
Page number?
Page number 54. Entire plot numbers are there, my lord, in tag number, including 11 and 23. And in Montobo column, Kua. That means Kua is there. Kua means depressed, Voska.
Plot number 11 and 23. Plot number 11 and 23 are Jomi Seni Danga. It is in the name of Nadu Bauri. Nadu Bauri is the prisoner.
Yes, father of my father, my lord.
Your father.
At that time, my lord.
Then what happened?
Then, my lord, upon dismissal of the my last writ petition.
No, why are you jumping, sir? This is their report of the committee. They found these plots to the extent of 0.14 acre was subsidence.
Yes.
Is a subsidence area.
Yes.
Now that means it become depressed. Then what happened?
That term is Voska. Commonly known.
Very good. Then what happened?
Then, my lord, I'm relying upon that memo, my lord. I challenge the writ petitions, and that is at page 152. That was.
What is your grievance in the writ petition? Why have filed the writ petition?
For compensation, my lord. As because they should purchase. Upon relying upon.
Why are you jumping?
I'm sorry.
So.
Upon relying upon my previous agreement, my lord. If there is a total depression, whatever may be the plot of land, whatever small unit, they should purchase that amount. Clause 7 of at page 1 or
in the event consequences, the land with Ato, it would pay such compensation as 7. Except in the Ato prosper, the company will have no responsibility.
Exception clause, page 60, my lord.
That in case of particular portion or piece of land is found in a very exceptional unusual irregular subsidence
Yes.
resulting in as well as like very depression known as Fosca, making the leveling of the said piece of land impossible. The company shall purchase the said piece of. So, according to you,
Yes.
it has become so depressed,
Yes.
it is unable to use.
And they should
Therefore,
purchase.
they, as per the terms of the agreement, they are bound to purchase.
I'm deeply obliged to your Lordship.
So why are you not saying this?
Yes.
I have filed the writ petition. I don't know why you have pre-filed the writ petition.
That
Then
was
what happened?
relying upon that last memo, my lord, of that they admitted that.
Very good. Then what happened?
That was dismissed. I preferred an appeal, my lord. But kindly come to the appeal at page 154, starting from 154. And in appeal code, my lord.
Page in 154 in Matt judgment.
And skipping the factual aspect of the judgment, my lord. I'm reading at page 55, last column, my lord, last paragraph. Could I use your Lordship, my lord?
Which paragraph is
Relying on at page 56, 156, my lord. Second paragraph. Without going into the question of whether or not in the notice of May 9, 2017 furnish a fresh cause of action, we dispose of the appeal and the applications by granting liberty to the appellant to make comprehensive representation to the appropriate authority in Eastern Coalfields Limited within a fortnight from date. If such
very good. So this representation has been submitted, which has not been considered.
That has been filed. Next page, next annexure, that has been done, my lord, page P15, 158. And they,
158 is your representation.
Including all the annexures. And my lord, P19, page 194 is a notice. Notice of hearing. Pursuant to the order of the division bench. Representations should be made and they should give us a hearing.
Hey, flag देखी भाई, flag
154 ना? No, get about no, order of division bench.
Now, on the basis of the representation, what they have held?
My lord, kindly come to the notice once.
What is the notice?
Page 194. One with not even 24 hours notice, my lord. Kindly see, my lord, notice dated 5th of July 2023, and my lord, hearing fixed on 6th of July 2023 at 10 a.m.
Page number.
Page number 194, my lord. Losses got it, my lord. 194.
Sir, there may be.
My lord. Yes. Oh.
Yes, sir. What have you got to say with regard to page number 194? There is a notice.
The notice, my lord. Notice of hearing pursuant to the order of the division bench.
No, why have referred?
My lord.
Why you have referred the notice?
Because, my lord, kindly see, there cannot be a notice which has been given date. Kindly see the date at the top, my lord. 5th of July 2023.
4/7.
4/7 or 5/7.
You participated?
I personally went over there, my
lord.
Oh. And kindly see, fixed on 6th of July. Not even 24 hours.
Be there as you participated.
I participated, madam.
Then what happened?
But kindly see, I also, my lord, filed my written notes of argument. Next page. And the order impugned.
Where is the order impugned? Where is the order impugned, sir?
Impugned at page P20, page 204.
Rescind order.
Yes. Just stating that this is rescission order.
Page number 204.
Now I have dealt with this order impugn. Paragraph 36.
Please, sir.
Yes. But in the first few pages, my lord.
Where are the perversity in the order?
Yes.
That is please.
First perversity is that, my lord, I've placed that in page 31, para 31. Gurudev. Yes. First of all, my lord, 36, paragraph 36. Sorry. Yes. But there has been no formal assignment. The order, my lord, kindly see, I've stated in my written submission also, on the same date that hearing was to be supposed to be taken by, my lord, GM Kunusturia, because he has given notice, my lord. Notice at page 194. Page 194 is a notice. Hearing should be taken by General Manager Kunusturia area. He, my lord, appeared, and my lord, I have written that in page 195. Though the hearing was less than 24 hours, my authorized representative such and such is there. General Manager Kunusturia, who is the presiding officer at the hearing, presided the said meeting at about 10:45, but very strangely, however, left the hearing most abruptly after 15 to 20 minutes, stating thereby his subordinate will.
No. Who passed the
same person?
Then Mr. Mukhopadhyay, where is the?
He was not there. I personally appeared in the hearing matter. He came and without any formal assignment to any subordinates, my lord, he left the meeting. He left the hearing, my lord. So, my lord, my point is that, my lord, no formal assignment is there. He had only signed the.
Mr. Mukhopadhyay, what I'm on, I understand your contention.
Yes.
The person, according to you, the person who issued the notice.
Yes.
He was present in the hearing for some time, and then all on a sudden he left the place.
He was the presiding officer.
Yes.
So presiding officer either should hear the hearing personally, my lord, and pass the order, or my lord, he should assign somebody else, his subordinate. There is no formal assignment. That cannot be done. Is a my lord, it should be a reasoned order, pursuant to, my lord, order of the division bench. And, my lord, next point is, my lord.
No, wherefrom I will get that? Wherefrom I will get that? In the midst of the hearing, the general manager left the place.
But my lord, on the same date, my lord, I filed, my lord, that has been stated in that hearing, in this memo also. In the order impugned, it is stated that. But kindly come to, my lord. Yes, but at page 209, my lord. So big petition. Page 209 on 6th of first line on 6th of July.
What is this? What is this?
This is a order impugned.
Sure. Please.
On 6th of July 2023, the applicants were represented by the learned advocate Sri Subsidy Mukhopadhyay, who verbally stated all that was already reflected in the comprehensive representation, and also submitted a written summary of the important points together with photographs of some other. This is at page 195.
Kindly please, sir. Where is the perversity in the order? So,
my lord, he was not there. I've stated that in my written summary.
Huh?
I also submitted a written summary of the important points together with photographs. In the written summary at page 196, I've stated that he was there, that general manager was there for 15-20 minutes and then left without any.
How do you anticipate that he will leave and you have included those in your written summary?
No, I was there in the hearing meeting. I personally was there.
So in his presence, you prepared that.
No, I prepared immediately.
Page number 195 is your written notes on argument.
Yes, yes.
You said
Yes, yes. On the same
in course
data-
of hearing that in the midst of hearing the general manager left.
Yes.
This is your contention.
Yes.
And that point is included in your written notes on argument.
Yes, yes.
So how can it be?
On the same date, I filed this. That was stated.
Try to visualize my position.
Yes.
In course of hearing of the instant writ petition,
Yes.
you file a written notes on argument.
My lord.
Now, at 114, I leave the low court instead of 115. So how do you incorporate that in that factor in your written argument, which has been prepared on an earlier occasion?
This was filed on the same date subsequently. After the hearing, my lord. On the spot, my lord. I prepared on the spot and filed it. Because they also stated that on the same date, my lord.
So no oral hearing took place.
Oral hearing was not took place before the presiding officer. This is my specific case, my lord.
Presiding officer is the general manager.
General manager.
No,
He has been
how do
directed
you
by.
prepare this?
Hello?
In his office, you have machinery, printer, computer. I believe you can
No,
keep
my
a kit.
no.
How do you prepare that?
No, my lord, that has been prepared on the same date. I filed it on the same date.
Be there as it may. What happened thereafter?
Yes. Next, my lord, para 37, my lord. Impugn order, my lord, neither referred as the agreement dated such and such. The my lord, agreement relied upon.
On what ground they have not considered your representation favorably? So show me that relevant portion.
Kindly come to page 209. It clearly shows that the aforesaid land was used such and such. Further, in the year 1979, they have admitted 3 agreements were executed, being deed number such and such, measuring 1 acre was included in deed number such and such, was included in and crop compensation included was leveling of the land. Out of 10 plots mentioned in the representation, only plot numbers 4.4567 and 25 were taken on lease. They've admitted, taken on lease. ECL for 3 years on a basis of lease agreement dated 3/2/1979. Beside these, the plot number 4 and 4567 were also taken lease agreement for the mining purpose. The compensation against these plots were already been given to the appellant. The compensation is only crop compensation, not for Hoska, not for depression. The remaining plots are remained custody.
No, out of the 10 plots mentioned in the representation, only plot number 4 and 4567
yes,
and 25 were taken on lease for ECL for 3 years on the basis of lease agreement.
Yes.
And besides the plot number 4 and 4 was taken on lease agreement, mining agreement. The considered compensation against these plots are already given. The remaining plots were remain in the custody and possession of the applicant. The 3 mentioned plots were never purchased nor acquired by ECL for the purpose of mining. There is no question of payment of compensation for the use of 3 plots.
Kindly come to my next point, next page 210. There was no joint inquiry, no report was neither given.
The agreement you have referred covers which plot numbers? Wherefore we'll get the plot numbers.
He says, yes, my lord.
Wherefore we'll get the plot numbers in the agreement.
Page 61, my lord.
Page number 61.
Yes, my lord.
Yes. Plot number 4.
Other plots are there, my lord. Plot number 4, area 1.1 acre. Put number such and such. This is joint hearing was done for the 3 petitioners. Petitioner, 9, 10, and 11, my lord. Other plots are there for other petitioners also.
So plot number 11 and 23 have become depressed.
Yes.
Plot number 11 and 23 as per their survey report, page number 106,
yes,
have been depressed. Then how you are affected?
But I prayed for some inquiry. That was done.
Sir, try to understand my question, Mr. Mukhopadhyay. As per the report of the committee, plot number 11 and plot number 23 was depressed to the extent of 0.14 acre.
At page 109.
106.
Yes, 106. That
How you are going to be affected? That I intend to know.
But that was in 2017, my lord. 106 is 2017. Thereafter, my lord, they stated over here in page 200 in the possession of the 10 plots mentioned in the representation, including such and such, were found in the custody of applicant, and no cracks, buildings, and stated that were found, and the house of the appellant are also situated on this plan and presently residing. There was no deformation such and such. So, if there is any inquiry, they should give the inquiry report. There should be a joint inquiry. But on similar manner,
no, your representation covers. Let me see your representation. Which plot? That I intend to see. Representation.
Pursuant to order of the division bench.
Yes.
Yes. What was my
all plots?
Yes, yes, all plots. Because subsequently, there are stated that there was a inquiry was done, but no report was given. But there is a order of the division bench of very recently, my lord, on the similar facts, my lord.
No, what is the as per this report?
Report was never given, my lord.
No, you have referred to a survey report, no?
Yes, yes, I refer to a survey report.
As per your report,
No.
As per the page number 106, plot number 11 and plot number 23 have been depressed. But what is the agreement to the plot number 11 and plot number 23?
My lord, subsequently there was a inquiry. I have stated that in my petition, my lord. Yes, my lord. But I am relying on this this judgment, but very recently, my lord.
I will look to the judgment, but first satisfy me factually.
No compensation has been given. Let them, my lord, de novo, my lord, hear out my petition.
Why?
That is my prayer, my lord, to withdraw, recall, and rescind, as because it is not at all a rescind order. It is very cryptic order, my lord, not at all a rescind order. No, hearing was done properly. They ought to have given a field inquiry should be there and find out what is what. Kindly see the photographs of annex, my lord, with the my written notes of argument. They have stated that how depressed is our land is there. Totally unusable. Photograph from 203 A, B. Totally unusable. These are the land they have taken, my lord. Losses note that very recently, my lord, on the 20th of May 2025, my lord. Can you see my prayers, my lord?
Plot number 25.
Yeah, very good. That is good.
Case number. This case number. Case number.
Under 358, 2019. In 2019. Delivered হচ্ছে 20 দেখো তোমার কপি দেবো।
What have you got to say?
Not the first I surprised that this is the same cause of action, fifth time filed the writ petition. Earlier, the first writ petition, Justice Honorable Justice Dadan Pinaki Ghosh has been pleased to direct to consideration. Second writ petition filed before Justice Samadar. His Lordship consider all the point and has been pleased to dismiss the consider all the point raised by my learned friend. Dismiss the writ petition. My learned friend file appeal. That appeal was also dismissed. If my learned friend file representation, again filed writ petition before Justice Honorable Sambuddo, Dr. Sambuddo Chakravarti. His Lordship was again dismissed the writ petition. Then again file appeal, I do not know exact. Then again filed one representation. In the order, region order, everything mentioned. Then again file Lordship writ petition before Justice Subra Ghosh. Yeah, Lordship again dismissed the writ petition. They again file appeal.
What is it? Come to the merit. What have you got to say?
Lordship, we have not taken his land. We are not interested to take land. That's all.
Land has been taken. Then we totally utilized and now unusable. But may I please hand over a judgment of a
General Magistrate, we are not interested in. Taken 3 years, we paid compensation as per the agreement. That's all.
Co-op commission is debt strip.
Take down.
But may I please hand over this judgment, my lord? Kindly consider
What do
this.
I do with the judgment?
But this is a similar set of facts, my lord. Division in order. Very recently, my lord, delivered on 20th of May 2025. On a division on similarly, my lord.
This court
are my plots, my lord. And out of those plots, my lord,
Lordship, 10, 11, same. 10 and 11, same, Lordship. Same order.
it cannot be same order.
You do it. Same order, person. Same order. Rajiv.
না থাকলে বলবো কেন মাইলরকে আশ্চর্য তো
Same.
No, cannot be, my lord.
See, Lordship, see.
Other plots are there.
No, follow other part.
same order
Every matter, same matter pass.
I'm not.
same report
The
mirror
committee was that.
same order 18
No,
23
Similar sets, my lord. With regard to compensation, my lord.
10, 11.
Kindly, my lord.
आचार डालो आज
Sure. Item number? The parties are not represented today. The parties are not represented on the last occasion, that is on 12/6/2025. None appears on behalf of the parties. এখানে আমার Mr. De Learned AGP file. Mr. De Learned AGP appearing on behalf of the writ petitioner.
My lord, yesterday we got the, my lord, affidavit in reply, my lord. So my lord, give some time, my lord, we are not prepared, my lord, because my lord, affidavit in reply, my lord, we sent to DPSC, my lord. So, my lord,
On behalf, you are for
DPSC has
the,
not summoned
you
it.
are for the
DPSC Hubli, my lord. District Primary School Council Hubli, my lord.
3 and 4.
But DPSC has not sent any further report, my lord. My lord, short time. My lord.
Number 60.
62 is appearing. File দিন 60 তো This will be before me.
My lord, I am appearing for the added respondent number 2. As per the last order,
আসুন
Area 43, we are for the state respondent. Area 47, that is dismissed for default. Just now.
very good. Next.
161.
কে উকিল বাবু কোথায়? Represented. এটা কবে বলেছেন? এটাতে আছে। হ্যাঁ। ও nobody is appearing. আসুন। It is the event. In the second evidence, then এরা কেউ আসে আর আগের দিনও আসেনি। না $61 এটা কোনটা হলো? 61 হলো? I'm sorry, 62 then. The parties are not represented.
I appear for the petitioner, my lord.
Who is for the state?
There have been 2016 matter.
Have you served notice?
That Mr. PK Ray and Mr. S. Mukherjee was appearing.
Serve notice, serve notice.
26th February they have appeared, my lord.
Before a coordinate bench.
My lord, that is
Not before me.
That is the petitioner's retirement benefits have been stopped.
I understand. Learned advocate,
I am for the petition.
But I appear for the respondent numbers 5 and 6.
To respondent board, your lordship.
This has been assigned by to your lordship. Now, we are a society.
Give me a second.
Yes, my lord.
Evidence have not been called for.
Subject to your lordship's kind correction, my lord, perhaps it is not required, my lord. I am asking for, my lord, consideration of my representation.
Give me a second, sir. Yes, sir.
Now, my lord, we are, my lord, a society registered under the West Bengal Societies Registration Act 1961. Now, my lord, the petitioner before your lordship, my lord, namely, my lord, the Patbhavan Society, my lord, they set up 3 schools at 3 different locations. Now, my lord, this dispute, my lord, is with regard to a school, my lord, situated, my lord, at 8/2 Goriahat Road. Now, this is the secondary school.
There is another school, my lord, which is at Dankuni, and there are other, my lord, one Montessori school, etc. Now, my lord, this is, my lord, this was set up by the society. My lord, all the returns, my lord, there is one PAN number. All the returns, my lord, are, my lord, given by through this PAN of this society. Now, my lord, sometime in 2021, my lord, since there was no managing committee, the district inspector of schools, my lord, appointed one drawing and disbursing officer.
By order of this honorable court.
No, I'm coming to that. Now, my lord, a writ petition was filed, and my lord, the DI was directed to reconsider the issue, my lord, with regard to the appointment of this DDO. DI, my lord, pursuant to order of this court, my lord, referred the entire issue to the board, West Bengal Board of Secondary Education. Now, the West Bengal Board of Secondary Education, my lord,
without managing committee, how a school can run?
No, with ad hoc committee. Ad hoc committee was
an ad hoc committee was constituted.
But I am appearing for the ad hoc committee.
7 members ad hoc committee. Now, my lord, time to time, my lord, this tenure of this ad hoc.
When the ad hoc committee was running the school, the DI appointed an.
No. Initially, DDO was appointed. Then, my lord, this writ petition was filed. Court directed the DI to consider the issue. DI, my lord, referred the issue to the board. Then board, my lord, formed an ad hoc committee.
I see.
Consisting of 7 members.
There is a provision in absence of managing committee. Either there can be an administrator appointed or an ad hoc committee. So, my lord, an ad hoc committee has
now, my lord, this ad hoc committee's term was extended from time to time. My lord, as per there are, my lord, these rules, my lord, this is a de-getting rule. These are governed by, my lord, 1969 management rules, my lord. Now, as per the rule, my lord, the tenure of this ad hoc committee should be limited, my lord. Maximum it's 2 years, but under an exceptional circumstances, it can be extended. Now, this 2 years have expired, my lord. Now, this ad hoc committee, my lord, filed a writ petition seeking extension of their term. That writ petition is pending. My lord, today that writ petition was taken up, my lord, by a coordinate bench of this honorable court, and their term has been extended, my lord, till 15th of September 2025. Since this writ petition is also pending. Now, we have filed this writ petition, my lord, seeking, my lord, consideration of our representations. We made 2 representations. One before the Commissioner of School Education, another is, my lord, before the board. Now, our prayer is, my lord, that we, my lord, enjoys, my lord, this special constitution, my lord. This special constitution is something, my lord, that we can, my lord, form our own managing committee. And, my lord, we should, my lord, may not follow the formation, my lord, as prescribed in the 1969 management rules.
That is in respect of grant in aid school.
Yes.
That rule is applicable in case of grant in aid school.
No.
That is, my lord, in case of, my lord, grant in aid school as well as, my lord, DA getting school.
Unaided school. DA getting is a separate aspect. Unaided school. The schools, the teachers of the schools who does not draw their monthly salary from the state exchequer. So this particular school is a part.
All aided school, my lord. This 69.
No. All aided school.
The rule which he has referred is applicable to which category of school?
This special constitution can only be granted to unaided school. Any aided school which is ruled under government, they don't enjoy any special constitution.
So Patobhavan is an unaided school?
Unaided school. Only recognized by West Bengal Board of Secondary Education.
My lord, may I, my lord, just indicate, my lord, the relevant provision, my lord. My lord, kindly.
No, maybe.
My lord, I am led by Mr. Gupta, my lord. My lord, Rule 8 of the 1969 management rules, my lord. My lord, kindly consider. Kindly consider Rule 8(3), my lord. Notwithstanding anything contained in these rules, the Executive Committee shall have the power to approve on the application of any institution or class of institutions of the special constitution of a committee in favor of such institution or class of institution, and in approving the special constitution of a committee, the Executive Committee shall pay due regard to the recommendations of the director, now it's commissioner, my lord, if any, while granting special constitution in favor of an institution or a class of institution, the executive committee shall ensure that representation of the members of the teaching and non-teaching staff, guardians, and the member nominated by the director or an officer authorized by him in this behalf is made according to clause 3, clause 4, and clause 6 of rule 6. Therefore, my lord, this in view of this provision, my lord, the board, my lord, will consider the recommendation of the director, now my lord, renamed as commissioner.
Executive committee means what? Which committee?
Executive committee means, my lord, the executive committee of the board, West Bengal Board of Secondary Education. Now, my lord, already
Executive committee means the committee constituted under clause A of the section 18 of the Act.
yes, yes, ma'am. My lord, executive committee, your lordship will find my lord, section 19A of the West Bengal Board of Secondary Education Act.
No, here it is written as executive committee means the committee constituted under the clause A of the section 18 of the Act. Which Act?
My lord, West Bengal Board of Secondary Education Act.
Act means West Bengal Board of Secondary Education 1963.
My lord.
So where is section 18?
My lord, section 18, your lordship will find page 6 of this book, my lord. If the, I do not know whether the pagination will tell you or not. Page 6. My lord, chapter 3.
It is 19A.
My lord, 19A is the executive committee. There are committees. Your lordship will find section 18. There are 5 committees. Then 18AA says executive committee.
Should the following committees?
Yes.
That includes executive committee. A. The
May I interrupt over here, Lordship?
Very good. The executive then
May I interrupt? Well, now this committee, as board is no more there, because board is defunct, there is no committee. There is an ad hoc committee is running the board. Since 2011, there is an ad hoc committee who is running the board. So, Your Lordship, all the powers of these committees under board, they are all run under ad hoc committee, and it is presided over by the president of the board. So, Lordship, any decision of any executive committee or any committee under this act is now taken by the ad hoc committee and the president of the board.
The board is also defunct.
Ad hoc committee. The board is run by ad hoc committee since 2011.
Why?
That I cannot answer, man. It is upon the
board is ad hoc. The school is ad hoc.
Everything is ad hoc.
Luckily, the court is not ad hoc.
So, now the power is in the hands.
Yes. Now, my lord, I shall draw your lordship's kind attention to page 130 and 131 of my writ petition, my lord.
Notwithstanding, any executive committee shall have the power to approve on the application of institutional classification the special constitution of a committee.
131.
So you prefer special constitution of a committee under this rule?
Yes, yes. My lord, I made a representation, my lord, the Commissioner of School Education, my lord. Earlier it was known as director at page 131, my lord. Kindly consider my letter.
Page 131. Yes, sir.
Now, my lord, page 131, this is my letter dated 26 May 2025, addressed to the Commissioner of School Education, seeking a request for recommendation for approval of special constitution. My lord, in terms of this rule 8.3. Now, your lordship will find that the Commissioner, my lord, will send his recommendations to the board, and board, my lord, having considered those recommendations, my lord, will take a decision. At page 130, my lord, your lordship will find my letter addressed to the West Bengal Board of Secondary Education. Now, both these two letters are pending for consideration. Page 130 and 131.
No, the commissioner will is duty bound to place your letter before the board.
No,
before the
Commissioner
committee
will take a, my lord, decision, and my lord, he will send his recommendations as per 8.3. Your lordship will find the 4th line of 8.3. The executive committee shall pay due regard to the recommendations of the director. Therefore, the director will, my lord, send his recommendations, and board is the ultimate authority, my lord, to take the decision. Kindly consider, my lord. And in
Oh, the executive committee shall pay due regard to the recommendation of the director. Here it should be read as a commissioner.
Commissioner.
So according to you, on the basis of your representation dated 26 May, the commissioner shall make due recommendation
Yes.
to the board.
My lord.
And on the basis of such representation,
the board will take a
the
decision.
board will take a decision
Yes.
in terms of your prayer dated 21/3/2024.
These are my prayers. And my lord, only one thing, my lord. My lord, I have referred to 3 schools. There is one school at Dankuni. Board has already, my lord, granted, my lord, that special constitution benefit, my lord, in respect of the other school, which is situated at Dankuni. My lord, this issue is pending, my lord, which is at 8/2 Goriahat Road.
No, Lordship, they have made an application before the Commissioner of School Education. So, my lord, that is on 26th May. So, my lord, whether the Commissioner of School Education, after considering, because a lot of aspects to be considered, my lord, that is to be considered by him. So, my lord, later direction may pass, my lord, upon the Commissioner to consider the application. If it is found, it is considered by him, and he recommends to us, my lord, we will, after considering, we will pass. If he rejects it, my lord, then there is separate. It is upon the Commissioner of School Education, because he will consider it in accordance with law. Because, my lord, only a line of application doesn't satisfy. There are a lot of others which he will ask for. Whatever other documents he required or whatever other things required, he will ask for, he will consider.
And after, of course, after giving an opportunity of hearing.
Not necessary, your lordship. If he fits, if the commissioner thinks he can.
Well, that is, my lord, I think, my lord, within the domain of the principles of natural justice, my lord, that benefit should be extended, my lord.
Very good.
And on face fit, your lordship, if it is not
Considering the representations are concerned, my lord, I have nothing really to say.
Very good.
I am ad hoc committee. I am only, my lord, kindly do not make any. I am beseeching your lordship not to make any observation.
No.
Only on the part that they are the persons who established the school, because the record shows otherwise. But today I don't want to go into that dispute.
let it be
He will independently decide everything.
let it be kept open for the Commissioner of School Education to look into the matter and decide.
Because why I am telling your lordship, my lord, why I make this submission, because in the other writ petition, my lord, they have filed an addition of party. In that, my lord, directions for affidavits have been passed.
Who are your clients?
West Bengal Board of Secondary Education.
West Bengal, there is respondent number?
Lordship, respondent number?
2.
No, not 2, your lordship. 4.
My lord,
respondent number 4.
Respondent number 2, my lord, I am for
My lord, he is appealing for Commissioner of School Education.
Respondent number 2, my lord.
respondent number.
Who is for the state? You are for the
My lord,
state?
I am for
He is
this.
for the state.
Oh. You are 5 and 6.
I am 5.
Ashut. The writ petitioner?
65 minutes.
নাম দিলাম তো এই নাম পেয়েছো এসে তো কৈলি ভট্টাচার্য
Past order in open court, how can I reconcile?
Kindly restore it, Milord. I was here, Milord.
I've never done it. You file appropriate, I shall come.
Milord, I will be in trouble, Milord. I am in trouble because I am not.
Sir, don't make such a request which embarrasses the court, please.
Kindly restore it. I will do it tomorrow, Milord. Actually, it is a.
File application, I shall consider.
That's true, Milord. I will be in trouble.
Sir, in my entire career, I never recall my order which has been passed in open court. This is very unjust. It will be very unjust.
The other side, Milord.
You come with an appropriate application, I shall definitely consider.
Milord, I am not.
Who is appearing in item number 65?
65, it's absolutely
How many applications?
Restoration, then substitution. Absolutely my fault.
Section 5 application to the both the applications.
Substitution, two of the petitioner died, and restoration, even if I don't serve the copy,
2019.
Lordship.
Old matter,
I
it
filed
was-
Milord,
6
opposition.
years.
It is
Where is
absolutely.
your restoration application?
Yes, restoration is can 1 of 2025. Absolutely my fault.
And where is the condonation of delay?
That is CN 2.
Can 2 and what is? Can 4. Can 4 is on substitution application. It will be tired. Can 3 is for setting aside the abatement.
What happened, truly speaking, matter was old one. It was appearing before the court of justice Kapur. I missed the list, and I thought that the client is not interested. That's why I also not diligently looked into. I stated it is our fault. And when we came to learn, that has also been stated, and the person who is the only Todbika, he died.
Milord, kindly see the grounds which he has taken. Milord. Paragraph 3, page 5, internal page 5.
No, substitution application.
No, substitution, kindly takes a letter, because unless it is restored, substitution petitioner died. Therefore, if your lordship don't allow, others are there, they can proceed. But regarding the restoration, I stated that page 5, paragraph 3, that the Abdul Hakim, the petitioner number 4, was the only Todbir.
No, please come to can 3. That
Can,
is to be taken up first, no?
no, can 1 has to be taken up first, subject to correction,
Can 1 is for?
Restoration.
Mr. Mukherjee, there is an application for restoration.
Yes.
That application is time barred.
Yes, that is can 2.
That is your file on section 5.
Can 2,
Section 5 is also belated. You have filed an application for setting aside the abatement.
Yes.
So which one is to be taken up first?
But section 5 in connection with restoration first. That is can 2. Because unless this is restored, and I have categorically stated, if your lordship see my application.
Oh, this one is for in relation to substitution application. I understand. So which one I will take up?
But kindly straightway come to can 2.
Can 2.
The section
There is
5
an application
for filing the restoration.
Restoration application.
But when the matter was dismissed for default, my landed senior friend was also not there.
So what?
I need not be served.
So
That is the law under civil procedure code.
So this is an application for condonation of delay in filing the restoration application.
Absolutely.
What is the restoration application?
Yes,
Can 1. Can 1.
Yes, madam.
Very good. What is can 2?
My can 2 is the section 5. But I stated
what is the relevant paragraph?
Yes. But kindly straightway come to section 5 application, page 5, paragraph 3. Your petitioner states that said Abdul Hakim, the petition number 4 was the Todbikar in the present proceeding, but unfortunately the said Abdul Hakim died intestate on 11/12/2018. The other writ petitioner were solely dependent upon Said Abdul Hakim, and as such, they don't have any knowledge about the pendings of the writ petition. Your petitioner stated that in the second week of May 2025, some person disclosed themselves officer of the attached to the Land Acquisition Collector Howrah came to the premises in question and tried to implement the purported notice dated 14/12/2003. Subsequently, after searching the old paper, Sheikh Abdul Halim, the petition number 6, find out a letter of the learned advocate of this honorable court and contacted the learned advocate at his residence on third week of May 25. The petitioner stated that after searching, the learned advocate Mr. Kaustav Bhattacharya informed that the aforesaid matter appeared before his lordship Ravi Krishna Kapoor on 19/12/2019. As no one appeared on behalf of the parties, his lordship was pleased to dismiss the petition for default. Your petitioner states that during pendency of the petition, but this is the explanation. Then, my lord, I have stated that why the learned advocate could not appear. Now, my lord, if your lordship kindly straightway come to the next, my lord, page.
Your paragraph 8 is more interesting, my lord. Kindly says. Paragraph 8.
Yes, my lord. No question of interesting. The fact I have stated. But paragraph 9 I have stated clerk mix and advocate also, my lord, could not come to court on that day, my lord.
You know, other writ petitioner, they don't have any responsibility.
He is the only Todbika.
They are solely
If
dependent on this
see
action.
once, my lord, the civil procedure court, the respondent also did not appear. Therefore, they have no right of audience at the time of restoration, my lord, because they did choose not to appear on that day also. But if you see the order of Justice Kapoor, and now, my lord, any condition, my lord, I am.
Take down. Can 2 up to
In my review, and in 67 there's a can 3 which is my restoration application because the review was dismissed for default, my lord. It was dismissed for default on 6th of May. In can 3 into 67
এটা সিপিআর পাবো না।
right, in
একটু রিভিউ
67
ফাইলটা দিন।
can 3 is in 67. 67.
So let us take up the review after restoring the review application.
Yes.
Yes, আসুন।
Review is permissible or not. Let me take a preliminary objection on the maintainability of the review petition itself. Why?
Maintainability has not been kept open, paper books have been filed. We are in the
No, no,
final hearing stage.
Not maintainability, that on that point. Maintainability without on the point after dismissal of the appeal, whether review can be heard. There is a decision, but just I very short on that point because if I can pursue,
I'll take up at the time of hearing.
if I can pursue your lordship, then your lordship need to go into the merits of the case.
Very good. I'll look into that.
Taken as a threshold.
Not.
Appeal we had withdrawn. Appeal has been withdrawn for my learned friend's understanding. But the order under review is at page 81 of the paper book.
Give me a second, sir.
Mal.
Yes, Mr. Bandyopadhyay.
But if your lordship now, you have to take the order under review.
এই দেখি ভাই, এই একটু দাও
Paper book.
পেপার বুক। Only one volume?
One word.
এগুলো কি আছে? কোনটা পার্ট 1? পার্ট 1 and part 2. Two sets have been filed.
Well, I'll just check the index. Two parts. No, two parts of it.
Which one is part 1? দুটো কি part 1 part 2 করে দিয়েছে, ঠিক আছে?
Part 1 is up to page 105 and part 2 is thereafter.
Huh? Will you kindly check? Because it has been written as part 1 and part 2. Kindly check.
The index is part 1 and part 2, but it is one paper.
It's a composite, no?
One part.
Very good. Yes.
Well, the order under review is at page 81. Well, the petitioners before your lordships were employees of Group C and Group D of the other backward class welfare department.
Page number?
But order under review is starting at page 81.
Yes.
But since it is not an appeal in disguise, Malad, I'll make my shortest possible submission. Only to point out the error apparent, Malad. But the petitioners before your lordship were Group C and Group D employees of the other backward classes department. But they were seeking the benefit of a memo dated 16th of September 2011.
Yes.
By which consolidated pay of the contractual employees was prescribed. But this this is at page 180 of the paper book. I'll come to it later, but for reference, Malad, the memo that they are taking advantage of is 16th September 2011.
Page number?
180. There's also at 50. Your lordship may take page 50 also.
No, I've taken page 180. I'll come back to page 50.
50 minutes. I had marked 50 minutes.
Very good. Then I'll come back to page 50. This court directed the review petitioner to implement the beneficial provision of this notification in case of the
petitioner.
Read petitioner.
But actually, the prayer was for implementation of two other memos. Dated 25th February 2016 and 8th of February 2019. These are appearing at page 57 and 59. But Malad, if your logic kindly takes, but from paragraph 17 of the order under review, that is at page 88.
Yes.
Paragraph 17. On perusal of the aforesaid relevant portion of the memorandum, as issued by the respondent state, it reveals to this court that the respondent state had an intention to provide security of tenure, appropriate emoluments, and some terminal benefits to the casual or daily rated contractual workers who have worked for a considerable length for more than 10 years. Admittedly, the petitioners before this court have worked not more than 10 years. At this juncture, if we look to the subsequent two notifications dated 25th February 2016 and 8th of February 2019, it reveals to this court that the respondent state, while issuing such notification, has again considered the eligibility of the entitlement of the appropriate emoluments, security of tenure, and certain terminal benefits to the casual, daily rated contractual workers who are working in different departments of the state, and categorize the said employees in different tables on basis of their period of engagement, such as less than 5 years, 5 to 10 years, 10 to 15 years, 15 to 20 years, and more than 20 years. On comparative study of the aforesaid three notifications, as discussed supra, it does appear that while issuing the subsequent to notification dated 25th February 2016 and 8th February 2019, the state authority has also considered the case of the casual, daily rated or contractual workers who had worked less than 10 years, that is, those employees who have categorized under two tables, namely less than 5 years and 5 to 10 years. In view of such categorization, in the considered view of this court, the ceiling of 10 years, as fixed by the respondent state by its notification dated 16th September 2011, had given a go-by. In view of the discussion, this court thus holds that the notification of 16th September 2011 has practically lost its significance in respect of those contractual rated casual workers who have worked less than 10 years. Sufficient material has been placed before this court, that's one, then the operative portion of the order. Now, my lord, if your lordship kindly takes the prayer is pertaining to, that is at page 27 of the paper book. Kindly, my lord, turns over to page 28.
Yes.
But the primary prayer is the mandamus directing the respondents, their agents, subordinates to consider the representation of the petitioners regarding their salary or remuneration as a contractual worker in terms of notification, that is P2 and P4. That is 25th February 2016 and 8th of February 2019. These are at pages 57 and
25th February
2016 and 8th of February 2019, which are at respectively pages 57 and 59 of your lordship's brief.
57
and 59 respectively.
Page 59. Yes.
And also not to disturb the peaceful works of the petitioner, so and so, so and so, so and so. So they wanted the benefit of 25th February and 8th of February. Now, my lord, kindly takes 57 first.
57 of the paper book. Yes.
57 is, my lord, I'm reading, my lord, one or two lines, my lord, only to give context to my next submission. That in this department numbers 9008F dated 16th September 2011, it was decided to allow appropriate emolument, security of tenure and certain terminal benefits to the casual daily rated contractual workers subject to fulfillment of the conditions therein. But kindly mark it, my lord. The fulfillment has to be of the conditions therein. Then number 3. Now, after careful consideration of the matter, the governor has been pleased to decide to revise the benefits as follows. What has been revised, my lord? Your lordship has found that from 7,000, the remuneration has been enhanced to 10,000, and for Group C, from 8,500 to 11,500. Your lordship has also
in respect of less than 5 years.
I'll come to it. That is, for all the categories, it has been enhanced. For all the categories, not only less than 5 years, 5 to 10 years, 10 to 15 years, 15 to 20 years, more than 20 years, your lordship will find in the box that all has been enhanced. Your lordship has found that by issuing this memo and putting in that category of less than 5 years and 5 to 10 years, the requirement of 10 years has been given a go-by. That is your lordship's finding. Now, my lord, also at page 59, your lordship will find this is again in further modification. This is in terms of their prayer, this is the P4. The question of further improvement of the conditions of service of the casual deliberated contractual workers engaged in various government establishment in terms of Memo 9008 F dated 16 September 2011 has been under active consideration of the government for some time past. After careful consideration of the matter, the undersigned is directed by order of the governor to say that the governor has been pleased to decide as follows: that with effect from 1st February 2019, the consolidated remuneration of the above categories of the workers will be revised as follows. Another set of enhancement is there in this memo. Now kindly comes to the bottom of it. Also the terminal benefit to enhance, then Roman 4. Tenure of engagement, yearly enhancement of remuneration, medical benefit, leave facility of the worker shall be guided by the provisions of so and so as usual. Therefore, my lord, what has not been enhanced by these two memos of 25th February 2016 and 8th of February 2019, the other terms and conditions of the memo of my lord, that 9008 is intact. What has not, the entirety of 16 September 2011 has not been given a go by, except for those features which has been enhanced or modified by 25th February 2016 and 8th of February 2019. These are only modifications of the earlier memo.
No. This is tenure of engagement, yearly enhancement of remuneration, medical benefit and leave facility of such work shall be guided by the. So these 2016 memo, these 2019 memo specify that 2016 memo is restricted to these clauses only.
Yes, 2016.
Where is
But
that? Where is that? Memo?
That is my lord, page 57. I just placed.
Yes.
Right. And oath, your lordship will find that oath is not giving a complete go by to the mother memo of 16 September 2011. These are modifying certain aspects of 16 September 2011. 16 September 2011 remains.
Show me that memo, mother memo.
That is page 50.
এই দেখি ভাই স্লিপ দেখি তো এই ফ্ল্যাগটা দিন না What is the mother memo?
Page 51.
50?
50.
Yes.
But here, but apropos to your lordship's finding, kindly takes the third paragraph. Third paragraph, fourth line. Third paragraph, fourth line I am replacing, my lord. May I place it?
Yes.
Governor has now been pleased to order that the casual deliberated contractual workers who are remaining attached to various establishments of the government departments, directorates, regional offices, other organizations for not less than 10 years continuously as on 1st August 2011 and have rendered at least 240 days each year will be allowed the following benefits. This your lordship has found that this has been given a go by because of the subsequent memo. Since these categorization of less than 5 years, 5 to 10 years has been given, this has been given a go by. But your lordship has not considered. If your lordship kindly turns over to page 51.
Just a minute, sir.
Right.
Page 33. Yes. Page number?
51. Lord, will kindly take serial number 5. The casual daily rated contractual workers who will complete 10 years of service on 1st July every year will come under the purview of this order, provided no such worker, if engaged after 1st of April 2010, will come under the purview of this order. Now, this is the part which has not been considered by your Lordship, my lord. This memo had to be considered holistically, my lord. My lord, this memo also says who will be eligible to come under the purview of this memo. My lord, the completion of 10 years is one aspect which your Lordship has found, my lord, in your Lordship's kind consideration. But what has not been pointed out, that admittedly all these petitioners are appointed after 1st of April 2010. Therefore, if they are not coming under the purview of this memo at all, the question of the subsequent clarifications, modifications, enhancements of the emoluments will not affect them as such. Now, my lord, just to, my lord, amplify this point that they were not engaged before 1st of April 2010, if your Lordship kindly comes to page 187 of the paper book once. $187. Well, this is the decision by which the posts, as far as the petitioners are concerned, were created on 24th of February 2016. This is the approval, my lord, creation of 30 posts of different categories to be filled up on contractual basis and engagement of 6 Karmabandhus on part-time basis for 6 newly constructed central hostels. This is created on 24th of February 2016. This is the approval of the cabinet. Now kindly take their appointment letters which were part of the writ petition. Kindly take page 33 as an example. There are several, but kindly take page 33.
Hmm.
33, your Lordship kindly takes. This is of one of the petitioners.
Yes.
In pursuance of order, taken page 33. In pursuance of order number so and so of the BCW Department, Government of West Bengal, and also on the basis of recommendation of the DWO backward classes, welfare and TD Purvo Mednipur so and so, memo so and so, the persons as detailed in annexure 1 are hereby engaged to the post of OBC hostel at Egra Jhatulal High School mentioned against his or her name at a consolidated monthly remuneration shown at column D as per the terms and conditions mentioned below. The remuneration for this contractual service, well, this is extremely important, is payable under the head of so and so following order numbers 1702 dated for 19 January 2018 and number 838 dated 28 March 2018 of this directorate. This has the approval of the finance government of West Bengal Vide UO number so and so dated 14th of January 2016 and approval of the cabinet dated 24th February 2016. That is page 187 I just placed. Terms and conditions of terms and conditions. Kindly takes number 3. No financial benefit except the amount of remuneration as mentioned above will be admissible. Therefore, my lord, your lordships can see that first of all, they were not engaged apropos the memo dated 16th of September 2011. Their engagement is quite divorced of the 16th September 2011, whose modifications they are relying on to get the benefit as far as their prayer in the writ petition is concerned. Their posts are created much beyond the period mentioned in Roman 5 of 16th September 2011. That was at page 51. They are appointed against different DOs in the year of 2018. No way connected to 16 September 2011. The similar engagement orders your lordship will find after 33 at page 36, where same clauses are there, same cabinet approval is there. 33, thereafter 36, then 39.
Be the resume. So what is the difference?
Well, the difficulty here is that the error apparent on the face of the order is that their eligibility was not tested by your lordship while disposing of the writ petition. Inasmuch as the date of appointment, your lordship has found that the 10 years of service for being eligible for the benefit has been given a go by. It is not applicable as far as the petitioners are concerned. At first, your lordship's finding is that in the 16th September memo.
But so far as the clause number 5, that is at page number 51 of the paper book, it is restricted in respect of memorandum of 16th September 2011.
Right. That is P2. That is P2 of the writ petition.
Absolutely.
So their benefit that they seek is in terms of P2. That I pointed out at page 28.
No. They seek benefit in terms of P57 and P59. Notification of the year 2016 and
the lordship has taken page 28 once, page 28. Kindly takes page 28 of the writ petition once.
I'm there.
Your lordship towards the middle of prayer A will find in terms of the notifications, then bracket open, annexure P2 and P4.
That is the notification dated 25 to 2016 and 8 to 2019.
Well, those two are modifications, but the main memo is kindly takes now page 50. Page 50 kindly takes.
That is the mother memo.
Yes, well, I need to indicate something at page 50. If you logic kindly take page 50.
Yes.
Kindly looks at the top of page 50. This is annexure P2.
Yes.
This is the memo benefit of which they seek in the prayers.
Then what is P4 then?
Well, P4 these other two memos of 16 and 19 are modifications of this page 51. P4 is page 80 of the paper book. But this is a clarification of page 59. Well, may I summarize the four memos in my way, Malad?
Give me a second, sir. Yes, Mr. Wadhwa.
Well, page 50 is the mother memo, in which page 51 is the clause I am pointing out, is the cutoff date of appointment. Page 57 is a modification of page 50 of 2016.
Yes.
Page 59 is a further modification of page 50.
Yes.
And page 80.
Just a minute. 16, 9, 11. Yes, page 59 is the second modification.
Second modification. And page 80 is the clarification of page 59.
Yes.
Page 80 is the clarification of page 59. Therefore, all are moving in a chain.
Absolutely.
Therefore, to take the benefit of page 80, which is P4, one has to come within page 59 because the clarification of page 59 has no separate footing. To take advantage of page 80, the petitioner must come within the fold of page 59, which is a modification of page 50, the mother memo of page 50. Again, page 59 has no separate footing if page 50 is not applicable to the petitioners.
Mr. Bandyopadhyay, please listen to me. I believe I have got your point. If not, please, I will allow you to make a further submission. Admittedly, 16th September 2011 is the mother memo, which deals with the improvement of the condition of the service, with a rider that this will apply in case of those casual, delegated and contractual workers who will complete 10 years service for 1st July. Every year will come under the U. Naturally, year after another, it will come.
They will come.
So, basic thing is that they have to comply the 10 years service.
Right.
Now, if I come to the memo dated 25th February 2016, less than 5 years, 7,000, it will be on 10,000. 5 to 10 years, 7,000 to 12,000. So, I have hold that by implementing this chart, the 10 years bar has been given a goodbye.
Go by, yes.
But go by, very good. So, would it be your contention that in order to get the benefit of 60 notification at 16 September 2011, he has to wait for 10 years of service? Otherwise, he will get this benefit.
No. My contention is at page 51.
Yes.
Roman 5.
They will get benefit of that.
No. Kindly take the last line of Roman 5.
Yes, sir. Provided that no
First part says that every 1st July it will be seen who has completed 10 years.
Yes.
This your lordship has interpreted.
Yes.
Can I take the second part of it?
Provided.
Provided no such worker, if engaged after 1st April 2010, will come under the purview of this order. This is the proviso. Therefore, this memo is applicable to those who were appointed before 1st of April 2010. This part has never been modified by subsequent memos. What has been modified by subsequent memos is the emoluments which is to be given. That is, in place of 7,000, 10,000 will be given. In place of 7,000, 12,000 will be given. In place of 8,500, 11,000 will be given, so and so forth. And this 10 years requirement has been given a go by as per your lordship's order. But my lord, your lordship's order is silent as far as Roman 5 proviso is concerned, and it has not been pointed out to your lordship's my lord that these petitioners are admittedly engaged in 2018 and 2019, which takes them out of the purview of this mother memo of 16 September 2011.
It was not brought to the notice.
It has not been discussed in your lordship's order.
No.
Now, my lord, in this light, if your lordship comes back to the order under review, kindly takes from paragraph 14, I place from 17, kindly takes from paragraph 14 at page 86.
Mr. Bandyopadhyay, please read paragraph 10 once.
May I read it, madam?
This judgment was passed in court.
Yes.
This judgment was passed in open court.
Yes.
Read. Paragraph 10, sir. In course of his argument.
I'm sorry.
Page 85.
In course of his argument, Mr. Basu also places his reliance upon notification of so and so as issued by the Finance Department. It is argued by Mr. Basu that from the very first paragraph of the said notification, it would reveal that the respondent state while issuing the said notification for modification of the emoluments of the contractual daily rated employees have considered those employees who can come under the zone of consideration under the said notification who have worked for a considerable period of more than 10 years and who have been recruited in the sanctioned posts. According to Mr. Basu, the classification
So that provision is that proviso clause was not placed.
Not placed. It was not placed, and also, Malad, it has missed your lordship's attention, Malad, that the engagement orders of page 33, 36, 39, 42, 45, Malad, these categorically state that your remuneration will be guided by this memo. Malad, kindly take page 33 again at the cost of repetition. This is their appointment order, which is part of the writ petition P1.
No. They want, they challenge, they want the financial benefit on the basis of the subsequent memo date 2016 and 2019.
2016, they were not born in the cadre at all. They are born in the service in 2018. They cannot be there in 20. No. They came in 2018 and 2019. Then the question is, what is February 2019?
So main contention, Mr. Bandyopadhyay, is yours that while passing the judgment dated 18 to 2024, either the notice of the court was not brought to the court or the court overlooked this portion.
It was not brought to your lordship.
There is a proviso of the clause.
Yes, Malad, this mother memo of September 2011 not only prescribes the emoluments, it has 2-3 parts. One part is the who will be eligible.
No such worker if engaged after 1/4/2010 will come under the purview of this.
This is one of the eligibility, right? This has not been satisfied by them. It is also, this memo also says that it will apply to municipalities and panchayat. This memo also says that if you engage someone like this, you will be penalized. So the mother memo has many facets, but all the facets has not been pointed out to your lordship.
Very good. Now you show me the relevant portions of the judgment, which is
But before that, at the cost of repetition, kindly take page 33 once again, Malad. Page 33. I have already placed it, but kindly takes it once.
Yes.
Well, this is one of the appointment orders of the petitioners. Kindly take serial number 3 under terms and conditions.
No financier except the amount of remuneration as mentioned will be
As mentioned above means mentioned in the memo of 19 June 2018, not the memo of 16 September 2011. This is in pursuance to order number 786, Backward Classes Department of the Backward Classes Department, Government of West Bengal, and also on the basis of the recommendation of DWO, BCW, and TD Purva Mednipur. The persons at details annexure 1 are hereby engaged the post of OBC hostel at Egra Jhatulal High School, mentioned against his or her name, at a considered remuneration as shown in column D. Now, kindly see column D in the next page. In column D, your lordship has found the remuneration mentioned already. This is the same thing mentioned in serial number 3, that no financial benefit except the amount of remuneration as mentioned above will be admissible. Now, if this be the terms of service, it does not mention any benefit as far as this 25th of February 2016 is concerned, and it cannot be, because 25th of February 2016 is a modification of 16 September 2011, which is not applicable for the petitioners at all, because they are being appointed after April 2010. No, 16 was existing, 19 was not existing. But their terms of service does not say that their emolument will be guided by 25th February 2016 and onwards, because 25th February 2016 was existing at that point of time. Their emolument will be guided by the annexure material at page 30.
This much.
Now kindly comes to your lordship's order, Malad. Submissions are up to Malad 13. Kindly take from 14. Paragraph 14 is at page 86. On perusal of the entire materials as placed before this court, and after hearing the submissions of the learned advocates for the contending parties, it appears that it is undisputed that the present writ petitioners have been appointed in OBCW category department as contractual employees, and their emolument salary has been mentioned in their letter of appointment which has been annexed with the writ petition. Admittedly, the present writ petitioners have been appointed in different posts, even in different categories and prima facie. It appears to this court that they cannot stand in a common platform.
Very good. Those can be skipped.
Then, Malad, I am skipping over to the next paragraph.
Yes.
In order to come to a logical conclusion as to whether the benefits of notification dated 25th February 2016 and 8th of February 2019 can be extended to the writ petitioner, this court proposes to look to the first paragraph of the memorandum dated 16 September 2011 as published by the Finance Department of the Government of West Bengal, and the same is quoted herein below in verbatim. In order to provide security of tenure, appropriate emoluments, and certain terminal benefits subject to fulfillment of certain conditions to the casual, daily rated contractual workers who have remained engaged in the various government establishments for a considerable period of more than 10 years in connection with the implementation of the various schemes or projects of the various departments of the government, two memorandum dated so and so and so and so were issued by the government of in the Finance Department. Pausing here for a moment. This quotation and the paragraph makes it clear that your lordship considered the first part of it, but Roman 5 was not pointed out to your lordship. Otherwise, your lordship would have considered. On perusal of the aforesaid relevant portion of the memorandum as issued by the respondent state, it reveals to this court that the respondent state had an intention to provide security of tenure, appropriate emoluments, and some terminal benefits as to the casual deliberated contractual workers who have worked for a considerable length of more than 10 years. Admittedly, the petitioners before this court have worked not more than 10 years. At this juncture, if we look to the subsequent to notifications of 25th February 2016 and 8th of February 2019, it reveals to this court that the respondent state, while issuing such notification, has again considered the eligibility of the entitlement of the appropriate emoluments, security of tenure, and certain terminal benefits to the casual deliberated contractual workers who are working in different departments of the state, and categorized the said employees in different tables on the basis of their period of engagement, such as less than 5 years, 5 to 10 years, 10 to 15 years, 15 to 20 years, and more than 20 years. On comparative study of the aforesaid three notifications as discussed supra, it thus appears that while issuing the subsequent to notifications dated 25th February 2016 and 8th February 2019, the state authority had also considered the case of the casual deliberated contractual workers who had worked less than 10 years, that is, those employees have been categorized under the two tables, namely less than 5 years, 5 to 10 years. In view of such categorization, in considered view of this court, the ceiling of 10 years as fixed by the respondent state by its notification dated 16 September 2011 had been given a goodbye. Therefore, my lord, this eligibility, other eligibility factors, my lord, has not been considered in the impugned order under review. And also, my lord, their own terms of engagement, which fixes their remuneration and makes it clear that your emoluments will be guided by this order and as mentioned in the annexure.
Any other point?
Well, this is
One thing I've just noticed, this goes, I asked both Mr. Bandyopadhyay and Mr. Dhar to address this also, that I've just noticed while I'm reading. Come to page number 57. Both of you, sir. Third paragraph. After careful consideration of the matter and in supervision of the aforesaid orders and all other orders issued by the department in the matter, the undersigned is directed by the order of the government to say that the government has now been pleased to order that the casual, deliberated and contractual workers. Yes. Now you come to page number 57. Benefits to the casual, deliberated and contractual workers. Right?
Page
59, 57. Because that is in continuation of that, no?
Yes, yes.
And again, the first line of page number 59, conditions of the casual, deliberated and contractual workers. Am I correct, Mr. Bandyopadhyay? Now, if you come to the appointment letter of the read petitioner as page number 33. Their appointment on the basis of a consolidated monthly remuneration. So, would it be your case also that these class of employees will not come under these categories?
Yes.
Because they are neither casual, not deliberated, not contractual workers.
No, they are contractual.
Contractual. Oh, they are contractual.
No, I cannot join an issue with that. Yes, yes. In serial number 1 itself, it is mentioned.
Oh, contractual.
Yes. So they are contract. That is not my case. My case is that my lord, I bow down to what has fallen from your lordship toward the first part of my lord, your lordship's summation that they are a class. Why they are a class? Because they are not appointed under 16 September 2011. My lord, kindly comes to the language at page 59 once. I am grateful to your lordship, my lord. My lord, kindly takes page 59. The question of further improvement of the condition of service of so and so engaged in various government establishment in terms of memo number 9008 FP dated 16 September 2011. This is the separate class. Petitioners are not appointed under this memo. Petitioners are appointed under the memo mentioned at page 33, 36, 39, 42, 45.
And they have been appointed not before 1/4/2010.
That also that. One is that they are ineligible as far as 16 September is concerned, and second is that their engagement will be guided by their engagement order, which fixes their remuneration and makes it clear that your remuneration you will not get any additional benefit except for the remuneration fixed in this memo. Therefore, my lord, to summarize, firstly, my lord, the order under review, the first error apparent and
Basic is that for that while passing the judgment, the proviso of the
Roman 5.
proviso of Roman 5 of the mother memo of 16/9/2011 has not been considered, and the second contention is that the writ petitioners were appointed under a different memo where their emoluments have been specifically provided.
Right.
Therefore, they will not come under any of the three memos.
Yes,
That
because
is your
the
contention,
effect of the order
which
under
have not been, which this court has got no occasion to consider at the time of passing the judgment.
Yes.
Basically, these are the
Yes,
contentions.
but the impact of the order under review is that it changes the terms of engagement of the petitioners.
Yes, that's true. Very good. It will be taken up tomorrow at 2 p.m. আসুন ওটা কি বললাম কত দিয়ে দিয়েছিলাম ওই জায়গাটা
Yes. Before rising, my lord, I have a matter running in this list for the last 2 days, from the morning, Monday to Tuesday. Without out of turn, the matter is taken by the learned advocate of the state, who has mentioned otherwise. The matter has been disposed of. Suddenly, I have noticed. I am the petitioner in this matter. For the last two, item number 46.
It was under the heading what?
In the dismissal heading.
Why I am not appeared?
I have been from the last Monday, Tuesday, both the first half I have been. Kindly bear with me. Out of turn matter, how could it be taken? I've asked Mr. the court officer.
Huh?
He has told that today the matter is not taken up. Kindly note it, because today, tomorrow I will have to listen me. আমি কোর্ট অফিসারকে জিজ্ঞাসা করেছিলাম, জিজ্ঞাসা করে উনি বলেছে আজকে এটা হবে না, গতকালকে হবে না, আজকেও হবে না বলেছেন।
This court is guided by its own counsels and direction. You pass it. Hey,
kindly see the list. There is no mention.
কোনো কথা বলার দরকার।
Matter is no mention, because today,
sir, matter has been fast, take appropriate steps.
But kindly note it, because I tomorrow